All right, the next case on Dr. Hicks versus Freeman, I believe that we are at the point of a respondent's motion to dismiss.
Thank you, Mr. Chairman, members of the commission. Relator has rested his case, and the case alleges that there were violations of a couple provisions of Ohio election law, specifically requiring the campaign committee to accurately report its contributions and expenditures. There's also an allegation that the treasurer failed to maintain adequate records of what was provided to her. But since the treasurer is not in the party, that's sort of a moot point, holding apart from the fact that you can't have records of something that no one provides to you. If there's an overriding theme in this case, I would suggest the theme is that obviously someone cannot report what you do not know. Mr. Hicks, implicitly or explicitly, made a promise to this commission. The promise was that at the preliminary review and subsequently as he was going through his voluminous subpoenas and document requests and so forth, he would prove to you a grand conspiracy in which my client, Mr. Freeman, and his campaign committee were allegedly involved, in which they knew full well what was spent and who spent it, and they concealed that fact by not reporting it in their campaign finance reports. That's what he said, but that's what he promised he would do. The information provided to you over 2 days of testimony, not to mention all the motions and the pleadings and the discovery that led up to this, show nothing of that sort. What do they show? They show a number of things that are interesting. For example, Exhibit W, the $290,000 email saying, from Constant Contact to Alan Freeman's campaign saying, please pay $290,000. Apparently there was an attachment to that, which we all found out about 3 weeks ago. But it's what the rest of the story is, that the woman, Anna Lippincott, who sent that email, told the treasurer of the campaign this was a mistake. This is not a debt to the campaign. This is not something that you need to report in the campaign. Don't pay any attention to that. That is not something that creates a duty on behalf of a campaign to report as a debt, something that, number one, she immediately disputed, because Susan Jones, as the treasurer of the campaign, knew full well there was no authority that any candidate would ever give to somebody else to spend more than 3 times what they had in their campaign account. And Susan Jones also testified that she was telling JPL and Associates and Jeff Longstreth exactly how much money was in their campaign account in real time. That was her testimony. So there was reason for her to dispute that. And she said this was shocking in terms of the amount that was invoiced or allegedly invoiced, which is why it made perfect sense that this was a mistake. It was never something, according to what Anna Lippincott told Susan Jones, that the campaign committee owed. So as interesting as that may be, and you may wonder, one, is the $290,000 was actually spent on the Alan Freeman campaign? We don't know that. Was all of it, some of it, or none of it properly authorized and owed by the Alan Freeman campaign? We don't know that either, because her testimony is we never got anything back further than that. There was no other invoice from anybody in terms of a lot of this stuff. The second thing that we talk about, first of all, generally, what are we looking at? We saw those videos on there, we saw some print ads, and Mr. Hicks has proven time and again something we never disputed. We never disputed the fact that Alan Freeman was involved in the creative part of creating advertisements, radio ads, TV ads, print ads. Of course he was. His pictures in there. He knew that they were being created. He created them with not with Anna Lippincott, who was in charge of finances, but with Megan Fitzgibbons, who was in charge of creative. I guess there's some dispute about, from Mr. Schweitzer, he thinks that either Jeff Longstreth or Megan Fitzgibbon, authorized the buy. Megan says it wasn't me. And I don't know the reality of that. It's an interesting conflict, but it might just be that he interacted, maybe not creative, and got the approval on the numbers from Jeff. That's consistent with the testimony. We try to find consistency where you can. But nobody claims that Alan Freeman or his campaign committee or his treasurer authorized the numbers that people are speculating about. So it may well be, that some of the ads that said paid for by the Alan Freeman campaign shouldn't have had that disclaimer on it, because they weren't paid for by the Alan Freeman campaign. They were never authorized by the Alan Freeman campaign. That is certainly possible. We don't have a false disclaimer allegation, but he never authorized anybody to put his disclaimer on something that he wasn't going to authorize, or that he hadn't authorized. And then the question becomes, is there any evidence at all, that Alan Freeman or his treasurer, the campaign committee, ever knew who paid for what ads, the total amount of what was paid, and whether whatever was paid for was chargeable to the campaign, or in fact was paid by somebody else as an in-kind contribution? A lot of what we heard is maybe entertaining. Obviously, the whole Larry household assault and the indictments are interesting, and they create media attention. But entertainment value is not a basis for going forward. Likewise, it's not uncommon. I've at least in the past, and I don't know with any current members of the commission, where someone says, well, I'm curious about, I really don't know what happened, and I would like to hear the respondent put their case on, because I'm curious about what the respondent has to say. That's something that often happens. But the reality is, curiosity is not a basis to go forward with the complaint. And if you don't know, after all that Mr. Hicks has presented, whether there's a violation or not, he has not made his case, and this case should be dismissed now, rather than however long it takes to continue. Since there is no evidence presented that respondents knew what they needed to know to report these items, the case should be dismissed. And just ask yourself this question. If you were the treasurer of the campaign today, and you had the benefit of all the evidence that Mr. Hicks has presented to you over the last several weeks, what number should you put in there? Who should you put in there as having either paid for it or having a debt? What date should you put in there as saying this is the date this expenditure happened? Because if you can't, as the members of the commission, tell Mr. Freeman this is the right number and this is what you should have done, how the heck is he supposed to know what you should have done? And by the way, knowing what you should have done is a requirement before you report anything. That's in the statutes, and I've cited the statutes in the outline as well as attached to their Exhibit D and to the complaint. 351710B talks about the information you need to know in order to have a proper report. You need to know, number one, if you're reporting contributions and expenditures. Contributions include in-kind contributions, and expenditures include debts that you incur. So it's most likely that if we're talking about something that was attributable to campaign in some fashion, in other words, something that was authorized, you either have debt because you have to pay for what you authorized, or you have an in-kind contribution because somebody else paid for what was authorized. Or you can have an unauthorized expenditure from somebody else, even if they slap your disclaimer on it, and that is not something you owe, and that is not something you report, because that's not something that you ever authorized. Is there any evidence that what he authorized, what they authorized, and how much? I would suggest not. Is there any evidence that this was in fact a debt, rather than an in-kind contribution or an unauthorized expenditure? There is none. Is there any evidence of when it was made? We have some statements here and there, but basically, you don't know when expenditures for what media was made, how it was made, to what stations it was made to. Yes, you got the attachment of the complaint, which lists 6 items. You also have an explanation of that, which we filed earlier this year with the Secretary of State's office, saying, look, we see these numbers. We don't know if these are numbers that we owe. We don't know who a constant content is. He didn't. I mean, maybe Susan Jones did. But the campaign didn't, and the campaign had no contract with Constant Content. So they so Constant Content is receiving an invoice from the strategy group for, I think, $137 and change or something like that, for 6 items, some of which clearly are not his, because at least the 6th item there is split between him and another state representative candidate. So you have these noise issues. Okay, is this a debt? Did they authorize it? They don't think they authorized it. And you are allowed to dispute debts or claim debts, but nobody even claimed this as a debt of the campaign. When was it made? To whom was the debt owed? Why was it incurred? And how much the debt was? And by the way, you would also note, for example, that $290,000 bill, $290,000 is a bigger number than 137. Who knows where the numbers came from? Who knows what was included, what wasn't included? And if nobody knows, we don't know. And if we don't know, we can't report a fictitious number. Now, the other possibility is it wasn't a debt at all. That the plan was to have a third party pay, or a third party did pay, legitimately or otherwise. Well, we don't know that. You can't report it as an in-kind or as a debt unless you know which one it is, or whether it's authorized or not, and whether you need to report anything or not. If there was an in-kind contribution, who paid it? Nobody knows. We don't know, and you don't know. If there was an in-kind contribution, when was it made? We don't know. The evidence doesn't show that. If there was an in-kind contribution, what was it for? We don't know. And the evidence doesn't show that. How much was it for? Nobody knows that either. We can speculate about a lot of things, but we're not allowed to speculate. When you sign a statement under penalty of election falsifications, as a statement of a campaign expenditures and campaign finance report. Now, the allegation has been made, an argument by Mr. Hicks, well, you could have found all this stuff out. You should have looked for it. And once you looked for it, you could have found all this stuff out. Well, he's looked for it for the past years, and he didn't find it out. And after the teen householder folks were all arrested, and all their records were seized, I would suggest that it's going to be hard-pressed for anybody to find out until the federal prosecutor releases those records and we can sort through them. But we can't do that now, and neither could he. He could have called Jeff Longstreth to the stand. He could have subpoenaed. He chose not to do that. But it's not my place to make his case or to break it. The reality is there is no evidence that Mr. Freeman or his treasurer ever provided the necessary information to know whether or not the contributions and expenditures were authorized, and if authorized, what they were, and how to report them. 3517-081A requires all contributions and expenditures to be made through the treasurer. Now, what does that mean? It means when Mr. Hicks says, well, Anna Lippincott must have known, Jeff Longstreth must have known, they were working for you, so their knowledge is attributable to you. No, it's not, according to statute. The knowledge that we have is what vendors, which at best is what they were, inform you and give you information on, and that is the information the treasurer had a duty to maintain records of. And she maintained records of what she had. She couldn't retain records of what she didn't have and couldn't get, and didn't get from whoever it was that spent whatever they spent. Whatever third parties were doing, or were not doing, unless they notify and get authorization through either the candidate or the treasurer, it is not a campaign contribution and is not a campaign expenditure. Respondents did not know what they needed to know, and it is illegal to guess. Simply put, we should put this thing out of its misery now. There's all sorts of interesting things we could talk about in terms of the grand household thing, but the specific case here is, did Mr. Freeman and his campaign committee ever, according to the evidence Mr. Hicks presented, know exactly what they needed to report, by whom, by what, by when, by where, by how? And since we can't answer that question, and we can't answer that question, this case needs to be dismissed now. Thank you.
Go ahead, Mr. Hicks.
Amusing. I'll just address a couple things here. Is that one is, I know the amount, $290,000. I know the vendor, Constant Content. I know the date, March 18th. I know that because the treasurer of the campaign received that in an email and chose not to. do anything with it. I also know the amounts from Scott Schweitzer's provided invoices for what was involved, that the amounts were valid. I know that Constant Content paid the invoices on behalf of the Freeman campaign because Scott Schweitzer's affidavit said so. I know that Alan Freeman authorized things because these text messages with Megan Fitzmartin that were produced that have him authorizing things along the way. And so I think the funny thing is that these are charts I made for a close. And so just some of the things that he brought up, there's a couple pages out of the charts I intended to use as a close, since it was a sort of a re-argument of the case by Mr. Bry. And in a close, I don't want to go too far afield, but one of the things, there's a couple of the statutes involved in this case that have the word knowingly in them. And I put up here a definition of the word knowingly according to statute, and one of the lines I'll talk about in the close, assuming we get past this motion to dismiss, is acts with conscious purpose to avoid learning a fact. That's what happens when you don't open an email. That's what happens when you ignore things. That's what happens when you put. It's interesting that Mr. Freeman made an April 15th, 2021 filing to the Secretary of State without telling anybody, which I got an anonymous tip is how I found it happen. But he didn't make a July filing when Scott Schweitzer gave a determination of how the invoices have been paid in a subpoena, in an affidavit. So I want to show something here. And hopefully this works. I wasn't prepared that I thought I was going to be using these right now, but I'm glad I'm set up. So this is because I thought it was amusing during the whole case, Mr. Bry's constant, you can't report what you didn't know.
This is a simple case that I think is getting convoluted by all these promises to prove things that we never disputed.
That's what it was
No
open.
dispute, we have never disputed that there were advertisements that ran with our disclaimer on them, that we participated in some of the creative development of these ads. That there are, and that worked with some folks from JPL, among others, to help make them happen. We knew that ads ran. We also knew that we did not know who paid for them, or what the final invoice was, or how to report them. The simplicity of this case is by quoting the statement that Mr. Hicks made in his deposition. And I quote, obviously somebody cannot report what they do not know. And that, by the way, is an accurate statement of the law.
Montage here.
Would you agree you can't report what you don't? Yes. Yeah. Would you agree that as a principle you can't report what you don't know? I would agree with principle.
So I just thought since he brought that up, as he said, the cornerstone of a motion to dismiss, there's examples of Mr. Bry repeatedly putting these words in people's mouths about what, to answer this, to make the foundation of his case. I made a foundation of a case by people testifying to things like that Anna Lippincott and Steve Carraway had a discussion about how they were going to raise money to pay off the bills. Okay, like that Steve Carraway had a conversation with me about the bill, like that Steve Carraway had a conversation with Nick Owens about the bill, like that Steve Carraway said that he certainly at some point had a conversation with Alan Freeman about the bill. Okay, so, but I think throughout this case, there's been this kind of deceptive, let's put words in people's mouths so you can't report what you didn't know, be the cornerstone. So what I did is I made a contemporaneous copy of my deposition where Mr. Bry made a representation as to what I had said in my deposition. So I want you to hear what I actually said in my deposition, okay?
Does this address the motion to dismiss?
Yes, because he keeps referring to this, you can't report what you didn't know, and that everybody testified. It is exactly what he has on here. Everybody
Mr. Hicks didn't
testified.
testify. I didn't cite his deposition in my argument.
I would like to play what my actual answer was in the deposition for the question where he maintains and maintained in this room that I said you can't report what you don't know. Are you objecting to that? Because if you make a ruling on it, you tell me I can't play it. Are you objecting?
Yeah, I object. It's not an argument I made. He's refuting an argument I didn't make.
Typically, when we have motions that are pulled over in this fashion, you're not putting the actual evidence back up, that you're making the argument in front of us.
We were there, we heard the evidence.
Well, but you didn't hear my deposition.
I'm
So
seeing
let
myself.
me just say what verbally I said in the deposition. He asked the question, they can't report what you don't know. And he says, I said yes. And I said, yes, you can't report what you don't know, but they knew. okay? And the treasurer knew what was going on, and the campaign knew what was going on, and they did nothing to try to solve this issue. They ignored the issue and put their head in the sand. That's the part of my answer he didn't bother to tell you, okay? And so this whole motion to dismiss, based on this, I don't know what the campaign finance world would look like in Ohio based on Mr. Bry's logic. The logic that ignorance, claiming we didn't delegate my homework, my invoices disappeared, you can't report what you don't know, even though your treasurer got the emails, that everybody said they were confused, they didn't distinguish between constant content and JPL, you file affidavits, et cetera, you're constantly not forthcoming. Here's the key thing, related to this motion, is a very simple argument. I proved left, right, up, down, front, center that they knew. That the team around Alan Freeman, and Alan Freeman himself knew, was personally involved in approving things that were going on in text messages. Okay, so I think the motion to dismiss is absurd. And I think it's like the fourth or fifth motion to dismiss this case with these flowery things. I think I actually did pretty much show a grand conspiracy. A grand conspiracy to thwart the campaign finance laws of Ohio with inane arguments that would basically make campaign finance laws mean nothing in Ohio. Because anything would go in terms of, I didn't know, nobody told me, I can't figure it out, even when I got the invoices in my email. Even when I got the invoices in my email. So I have some other little clips from the hearing, including back in December, I'm not gonna play right now, but back on, I might play in a close, but back in December, Mr. Bry said here, we never disputed these things. He said it when I played, he said it again. I'm looking forward to in the closing playing a clip of Mr. Bry in December at the preliminary hearing, and we'll see whether he was denying things at that point in time. So anyway, I don't think this needs much argument. I think the motion to dismiss is ridiculous. And I think I actually have done, I don't know what you could do more to prove that the entire organization, including Alan Freeman, was well aware, had easy access, and could easily have taken steps to try to clean up their finance reports. Let's remember, the phone numbers for Constant Content and JPL were the same phone numbers. The address was the same address. The people involved, Scott Schweitzer, for example, said, I'm easy to access. Alan Freeman's a 12-year friend of mine. When I ask Scott Schweitzer doesn't know me, he produced the invoices. So I think the whole motion is absurd, and we should move on, and Mr. Bry should present a case, and then we can get the closing arguments. Thank you.
Very brief, please.
Sure. Three things I want to respond to. Number one, Mr. Hicks said several times that these emails of Alan Freeman proving, quote, things, end quote. The things that he approved were the content of advertisements. There is not a single video or text message or exhibit presented by Mr. Hicks showing that Alan Freeman ever approved the amount of an expenditure or the types of amounts we're talking about here, certainly. So that when he said he approved some things, we agree he approved some things. As I've said repeatedly, of course we approved and participated in the creative of the advertisements. That is not the same thing as saying that we approved the numbers or the expenditures or the airing of the advertisements. Secondly, Mr. Hicks says he knows what we should have reported. We should have reported $290,000 debt to Constant Content on March 18, 2021. Really? Is that what the evidence says? Or does the evidence say that the person who sent that said, this is not something you should report? Does the evidence prove that this was in fact something that you should report, when the undisputed evidence is that this was sent in error and was not an accurate debt of the campaign that needed to be reported? Mr. Hicks apparently ignores that part of Susan Jones' testimony, but nobody has disputed that. That's the only evidence that is before the commission, that the Exhibit W $290,000 email is something that they were required not to report. Let's suppose we reported it. And it came out that we were told not to. Mr. Hicks would be right here saying that we falsely reported because we knew we shouldn't have reported. You know, it's not just a matter of not having the knowledge that you should report something. in terms of the $290,000, we had actual knowledge that we should not report. Thirdly, he talks about Scott Schweitzer. The invoice of Scott Schweitzer, by the way, was not to Alan Freeman. It was to Constant Content. And he says, well, I know Constant Content paid that because Alan Schweitzer said so. So who paid Constant Content, if any? Does he know? Do we know? Has he presented any evidence of that? He has not. What portion of that, if any, and by the way, it's pretty clear that not all of it is maybe most of it is something that, from Scott Schweitzer's point of view, they were attributing to him. But not all of it, and we didn't know, and we filed a statement in, I think, Exhibit I of our exhibits, as well as with Secretary of State, saying this came in, we never had a contract with Constant Content, we don't know if all, none, or some of this is stuff for which we're responsible, or whether it's going to be paid or was intended to be paid as an in-kind by somebody else, or whether this should be a debt, because nobody has sent this to us as a debt. And we don't know how to report this without guessing or doing it inaccurately. And apparently the Secretary of State is fine with that. I know the Secretary of State is fine with that, and I talked to him before we filed the thing. But nonetheless, Mr. Hicks says, well, this shows you knew that this was actually a full debt for the full amount, and you should have reported it at the time you filed the April 15, 2021 amendment with the Secretary of State's office. The evidence doesn't show that. The evidence doesn't show that there was any knowledge that this was ever sent to the campaign committee by anyone as a debt, or that we received notice of who paid it. So with those three items, I think it's pretty clear that the evidence is defective, it does not support a finding of violation, and if you can't find anything more than those two items, then I think it's time to end this issue.
Well, I've been presiding, I'm not the decision maker, but for those who are not attorneys, I want to let you know, the standard on a motion to dismiss means we have to weigh all facts in favor of the complainant and construe all the facts in his favor, as opposed to making a decision now on what we think is whether or not there's a violation. We have to say, construe everything in favor of Mr. Hicks, and if you can't find anything when you construe it in his favor, then the motion to dismiss should be granted. That makes sense to everybody?
Repeat that one more time.
Sure. When we're making a decision on a motion to dismiss, it's not making a decision whether there's a violation and weighing the evidence. When we go to throw this out on a motion to dismiss, we have to weigh all the facts in favor of the complainant. Any fact that could go in his favor, we have to consider that as in his favor.
Can I, you need to give the benefit of the doubt to that.
No, look, sorry.
I just want to make sure that people
No,
understand
no.
what I said. Sorry, I'm sorry.
No. Is there any discussion among the commissioners?
Well, I would like to say, after sitting through hours and hours and hours of this case, and in deference to what you just said, Mr. Norman, for me, the defense of somebody cannot report what they do not know as why this motion should be dismissed is just not persuasive. If that's the case, then I'm afraid this body would be opening Pandora's box for other campaigns to simply say, somebody paid for all these ads, we don't know how much, and therefore we don't have to report it as an in-kind contribution. So having said all that, I believe that the motion to dismiss is out of order.
Any other comments from the commissioners?
I move that we deny the motion to dismiss.
Is there a second? Having been moved and seconded. All in favor?
Maybe do a roll call on this one?
Okay, great. Roll call.
Gladly. Mr. Brommer?
And we're voting to dismiss, yes.
To deny the motion.
Deny
Motion to
the
deny the
motion.
motion.
Yes.
Thank you. Ms. Kaufman?
Yes.
Ms. Tavares?
Yes.
Ms. Cunningham?
Yes.
Mr. Norman?
Yes.
Chair Beatty?
Yes.
That motion passes 6-0. Mr. Bry, your case.
I would call to the stand Mr. Hicks.
Do we need to rearrange the room for?
Oh,
Do you want to move the lectern?
Yeah, we do.
Mr. Hicks, may be easiest for you to just sit right there at your chair, because we can all see you right there. Unless you want to move up here to the center, but I don't think you need to
No,
unless
I'm
you
gonna
want
put
to.
this stuff to bed. I'm not supposed to look at anything.
Little exercise.
Just stay.
I'm gonna turn this off so it's not a distraction.
I've been sitting for days.
There'll be discussion among all of us. I think we should.
Okay, at this time, I think we're going to swear.
Yes, we will.
I do.
Mr. Hicks, do you have a copy of the Freeman trial exhibits in front of you? Would you take a look at Exhibit V as in Victor?
V or V?
V as in Victor, rather than V as in Dominic.
What, that's what this is. This is the.
Freeman exhibits.
Do you recall when I took your deposition on July 13, 2021?
Yes,
Were you under oath?
yes,
Did you try to tell the truth?
I did tell the truth.
And after the deposition was transcribed, did you have an opportunity to review the transcript?
Originally, no, you filed it without my review, but then eventually I think you refiled it when I gave some corrections to the transcript on some spellings and other things.
Well, the question wasn't about my file. The question was, did you have an opportunity to review it after it was transcribed?
Not before you filed it with the commission, but subsequently I did have an opportunity to review it, and it was refiled by you.
And did you in fact review it?
Yes,
And did you compare Exhibit V, or at least a portion of Exhibit V, you took a video, by the way, of the deposition?
correct.
Did you compare the transcript with the video?
Not not end to end, but certain sections I would use the video to confirm, but I didn't do a comparison word for word.
And did you make certain corrections to the transcript?
Yes, certain minor corrections involving spelling and so forth.
And are those corrections reflected in Exhibit V?
I don't remember, Don, because I would have to see the original version with my corrections to know even what parts I corrected.
Okay.
But I remember, for example, the word Sybase software, which you asked me about places I worked, the word Sybase was spelled wrong, so that was a correction.
Well, if you take a look at, after the original transcript, I think it's page 170, there are some pages which have your signature on it.
Okay.
And if you turn to that.
Oh, okay. Well, I see, for example, Kathy Brinkman on one page, I flipped through where my mark is on there, where it was on.
You see where you say Chris Arquette, that's your signature on that page?
Where?
The page after the number page 170.
Number page 170. I don't see the number 170.
Look in the little squares on the fourth page.
Okay.
And after the type case.
Mine ends at 164.
Maybe I take a look at your book, make sure we're looking at the same
So
thing.
164.
Oh, I see what's happening. If I may, this is part of what you do. Oh, it looks like you convoluted a few things. but
I
this is-
never took anything out of that notebook.
Okay, well, let me give you the witness notebook then, rather than having your own, because I think that may
Ours
be.
look the same as his, Mr. Brad.
Pardon?
Mine looks the same as his. Where I've got two depositions, one ends in 164, and then there's one that ends halfway through at the page 170.
The one that ends in 70, he's talking about the next page, which is where we
Yeah.
believe Mr. Hicks' signature.
With the index to the exhibits, page 3 of number 8. Yeah.
That one says 3 at the top.
Let me
Not
flip
170.
this to them. You see that?
Mr. Hicks, if you were to look at the, because there's 4 different pages, there's 1, 2, 3, 4 on one page.
Yeah, but the number on that page is 3, not 170.
Yeah, that's right.
Right.
You mean where your signature appears?
Yeah, you
Yeah.
told me to look at
If
page
you-
170 and it's on page
If you
170.
flip to the official witness notebook,
Which one? This one?
the one I just handed you, yes.
Okay.
If you look to the page before, the sheet before that,
The sheet before the one you had opened
The
to?
sheet before the one I have open to. It looks to me that's pages 169
Okay.
and 170.
Yes,
And then after that, are the pages following that your corrections?
now just as a side note, in the book that you had given me as an exhibit book, that is not the same layout.
I
The
believe.
prior page is a different thing than that, and at least the one you gave me.
Is that the same as with the, is the prior page 169, 170 for the commission?
Yes. Yes, for me,
It's
it
like
was.
what-
Yeah. It's just basically the affidavit, the very last page of his first deposition.
Correct.
Yeah.
Well, Mr. I don't know how the error happened, but I suspect that what happened was the book that you prepared, you must have stuck something else in there that you stopped the other.
Never opened it up, never opened the volume stuff
Well, anyway, let's just use the official. Do you see your signature there? Chris R. Hicks,
up. On the page after
877.
170, yes,
With noted change.
yes.
And following that, are the pages following that excerpts from the noted change?
Yes,
And I believe you were under the impression that it was not necessary for you to, under Rule 30, to provide an affidavit, but you provided your signature instead.
correct.
At this point, I would move the admission of Exhibit B into evidence.
Which is the other part, right, not the part we're looking
No,
at?
it's the whole thing. It's the whole thing,
Okay,
including corrections.
thank you.
Well, since Mr. Hicks has said he has not opened that, he probably should take a moment to review it to see whether he's going to object to it.
I would have to, I don't believe I was ever provided with a copy that was after my changes, so until this notebook here. But assuming that my changes, that I would be glad to accept this exhibit under the understanding that the part in the back is actually my changes. So if anything was incorrectly transcribed, I would point that out later from my changes.
It sounds to me you're not objecting to
No.
Exhibit B then.
No.
So it seems to me it should be admitted to the commission.
With the addition of Exhibit B, I have no further questions for you.
Do you have any other witnesses, Mr. Bryan?
I do.
By the way, I could cross-examine myself if I wanted right now, could I?
This time, it's not your case.
No, the guy was called as a witness. So if I had a lawyer, the lawyer could ask questions to follow up on his question, would be correct?
That would be correct.
I don't have any questions for myself, but I just want to point out when we get into this that I'm representing myself, so I have the right to question myself. Because I'm both a witness and I'm representing myself.
And I agree with him. If someone is a witness and also either counsel or representing themselves, they can cross-examine themselves, which is what I'm going to do. I'm going to swear myself in as a witness as to communications I've had with third parties.
If you become a witness in this action, I think you now have a conflict representing this
How
action.
do you do that?
Well, actually, I ran that through 3.7. I ran it through our former firm's ethics counsel. I'm the current ethics counsel. And I also ran it through the Board of Professional Responsibility, all of whom stated that they believe I have no ethical issues under Code of Professional Responsibility. 3.7 testify about communications I've had with third parties, where number one, it's not being contradicted. And number two, I'm in a unique position to represent the client in this case, and nobody else can really talk about that to the extent that I could.
If you're swearing yourself in, you're opening yourself to cross-examination, which is going to open you to attorney-client privilege. You can't hide behind a wall. So if you're going to do it, I think you got a conflict.
Well, first of all, the ethical issue is not something this commission has authority to do. Secondly, you're incorrect. The cases in which lawyers have testified, as long as they're not testifying about attorney-client privilege matters, that does not open up the attorney-client privilege.
Mr. Richter?
Yeah, he and I talked about this, and certainly it is an oddity for the commission to get this, but, it is his choice to subject himself to this. So I think he's okay.
Can you cite a case to tell us that?
Um,
That would be helpful. Like, I just
so
want
let
to.
me see if I have one.
I've always known in my actions, I've always had to recuse myself.
Right.
And I objected that there was obviously a sidebar with Mr. Ricker that I never knew about, talking about this very issue, and I never had a chance to prepare notes, to seek opinions of other people as to whether this was proper or not. This is totally improper to come up. Now, if we want to have a continuance so that we can go do proper research and get another opinion, like taking the 5th, then let's do it, but I need to sit here and contemplate this a little bit. I love the idea of Mr. Bry opening himself up, but if he's going to open himself up, he's going to open himself all the way up, including he's going to surrender his Fifth Amendment right to protect himself from criminal matters.
Well, I'm not claiming the Fifth Amendment right on behalf, but the attorney-client privilege belongs to the client, not the attorney. I would cite Rubin versus, Mentor Lagoons versus Rubin, Ohio Supreme Court case 31 Ohio State 3rd, 256. And this is under the old disciplinary rules, but the head note 1 of the syllabus, which of course is what the law is, states that DR 5-102A, the predecessor to 3.7, does not render an attorney incompetent to testify as a witness in a proceeding in which he is representing a litigant. When an attorney seeks to testify, his employment as counsel goes to the weight, not the competency of the testimony.
That doesn't answer the question of opening the door.
It does not.
It just answers the question of that you can testify.
Well, even when you testify, I mean, if my client can testify, but you can't ask him questions about attorney-client privilege unless he opens the door in his testimony. In other words, attorney-client privilege is a privilege that's
It'd be different if your
specific
client were
questions.
testifying. This is now you wanting to testify.
I don't know.
There is nothing in the evidence rules that makes a lawyer's testimony as to facts inherently inadmissible.
But doesn't it disqualify you as counsel in the case?
No,
if you
not-
take the stand?
No, not in cases in which, you're uniquely valuable in this case, which I think fairly, or actually there are, under Rule 3.7, a lawyer shall not act as an advocate at trial in which the lawyer is likely to be necessary witness unless, number 1, the testimony relates to an uncontested issue. The arguing witness is contradicting it. Number 2, it relates to the nature of valued legal services, which aren't what we're talking about. Or number 3, the disqualification of the lawyer will work substantial hardship upon the client, which I think it probably would.
I mean, what I'm having trouble reconciling.
And also, that's what I talked to the board about. They were of the same view. I mean, obviously, it's an informal conversation rather than informal opinion, but I did have that conversation.
I personally, go ahead, Otto, I didn't mean to.
And excuse me here, what I'm having trouble reconciling is what portions of the complaint is your testimony necessary to defend? I mean, I know, listen, throughout these whole proceedings, and I know there's also been evidentiary motions and everything like that, there's been a lot of, this person said this person said this person misrepresented me, and this person is making me do this, and all of that. But when we get to the heart of, what is the potential violation of the elections laws, I think I'm kind of getting lost in here as to why we're spending so much time on I'll just state it in plain language. The issues between the advocates, because I cannot call you an attorney. And so, Mr. Brad, I'm not really asking for a proffer per se, but maybe I am asking for a proffer. What parts of the complaint is your testimony defending against?
Your Honor, that's a fair question and may help put this into focus exactly what am I planning to talk about. After the last hearing, when Susan Jones was deposed, I thought Mr. Dick did a pretty good job saying that some of these statements that are made in the representation of the Secretary of State's office on the amendment are things that were not necessarily within the person's knowledge, because that involved what a lawyer said or didn't say to Phil Richter, for example. I would testify that when I talked to Phil Richter the end of July of last year, a week and a day after all the arrests, I said, I represented a client, didn't say who it was, and the client, has not gotten a bill from JPL, and I don't know, I don't know that we can report that. And yes, it's not an advisory opinion, but he said it makes sense that if you don't have a bill from people, you can't file a report about that. And that goes to Mr. Hicks' repeated statement that there's a grand conspiracy. In other words, it's reasonable for folks to believe that if the staff council of this commission thinks something's reasonable, it's reasonable. Secondly, I had conversations with Brian Katz, the Secretary of State's Campaign Finance Council, about the amendments once we learned for the first time on April 9, Friday, April 9, of the invoices that were sent from the strategy group to Constant Content. You know, that basically.
Mr. Bryan, can I stop you for a second? Because it seems like now you're giving your testimony without testifying. What I have a problem with is the precedence this could set. Because what it allows is counsel to testify and keep their client from testifying. If we're going to go with this approach and you're really intending to testify, I would like to continue this so that I have a chance, and we all have a chance, to consider the research and look at it. Because I've been a civil trial lawyer for 31 years, 32 years, and I've never come across this. And I've had, on many occasions, had to recuse myself because potentially I'd become a witness and I had to avoid the appearance of impropriety. So if you're really intending on testifying today, I say we continue this until our next hearing so that we can actually have an opinion. It would have been nice to know before today, but that's my thought on it.
Well, may I at least make
Can I
a
say
profit?
No, why don't we let the commission discuss it, please?
I agree.
I
It's-
agree.
It's very unusual. Maybe, okay. My initial reaction is not, but that doesn't, I don't know. I don't know. I agree that we need more information if we're gonna allow it. And particularly if it's all related to conversations, then probably, Phil, I mean, you can call the other person, it's hearsay, but you can also call the other person as a witness. So I don't know. I'm very torn about it. I agree that we need more information if we're gonna go down this path.
I think, from my perspective, I agree with the chairman and I'm wondering, Mr. Gray, why your testimony would be so instrumental here. The complaint asserts that the respondent did not provide complete information in certain campaign finance reports. All through this hearing, we've had all kinds of documents presented to us. It seems like we're now at the point where you have a witness who was part of this, integral part of this. Now, it wasn't you, it was him. And I'm not sure what your testimony is going to add to this commission to make a determination on who's right in this case. Secondarily, I think the complainant should have had an opportunity to know that you were going to testify. So he could have presented or been ready with any objections he might have. To spring this now, I agree, I think, I can't believe I'm saying this, that I agree that we ought to extend this to another day of hearing, but I don't know what else we could do.
Mr. Bryan, is it really your intent on testifying? If it is, I think we need to continue this matter.
Well, if I may respond
Yes
to
or no?
one thing that Mr. Bromer asked me.
Yes or no?
I mean, I want to get the thing done.
We all do, trust me.
You know,
We'll be back in January.
my concern is, I understand that the difference in terms of the standard of motion to dismiss and final one, but my concern is if in fact the commission is going to say, well, we're going to speculate on things, that maybe this happened, then we need to close all the doors. For example, Mr. Bromer properly said, how's this help anything? You know, and he said, we've never really tried to find any information. I talked with a lawyer for Constant Content, said, send me anything, Sean we owe anything. He said he was going to track it down. Now you're getting back to the argument
Okay,
again.
so.
I understand, but that's the evidence that I would present if I were
Are you
allowed.
intending to testify? That's the question.
That's the point.
I have proposed to testify.
My question is, do you intend to
If
testify?
you tell me that if I testify, you're going to continue the hearing, not get done today,
That's correct.
then I think that I'm entitled to a profit, but I also want to consult my client before we decide what we're going to do.
Why don't we take time
Can
to
I make any
recess?
comments, or am I not?
Not
He's
yet.
constantly making comments, and I don't get to say anything?
Not yet.
Why don't we take a 10-minute recess?
Okay, and any proffer, I think, should be outside of the hearing of the commission.
I agree.
Okay.
Actually, I've got a written proffer, we've got.
Would have been nice to provide this.
It's 10:37. Want to come back at, how long do you need, Don, to confer with your client?
10 minutes is fine, it might
Okay.
take less than that.
Alrighty.
See you.
I'm unplugging my computer power so I can in case somebody wants me to drop it.
Yeah, I didn't bring sunglasses.
Alrighty.
You, yeah, and you say, do you want the room? Yeah, if you want the room here, well,
It's easier for me to move than for you guys.
Well, you think, but there's a lot of people around the others. So we'll leave if you guys come over.
we gotta make it kind of sense.
I'm ready.
We're going to go forward with the rest of the witnesses and defer the decision on the necessity of my testimony until after that.
You may proceed.
And our next witness will be Phil Richter.
Unpopular items. I don't know if you work for the hearing, but
Swear the witness in.
I am.
Mr. Richter, is it common for, say, Dominic Todd or me to contact you and ask for your informal view of what should be done in the future with respect to campaign finance?
Not just you two, but a variety of people from across the state, yes.
Do you recall in July of 2020 when the Laird household and other people were arrested?
Yes.
Do you recall about a week after that I phoned you?
It has been mentioned here before. I know that you and I have talked, but I don't specifically recall when.
Do you recall me indicating to you that I had a client who probably owed something to JPL, Jeff Longster, but had never received a bill?
My recollection was you indicated that there was a client that owed something but didn't know what it was. I don't recall that you indicated JPL, Jeff Longster, content, anybody else like that. I just recall a much more generalized conversation.
Do you recall me asking whether or not it would be appropriate or inappropriate not to report it if we hadn't received a bill?
Can I interject here? It seems to me that counsel's trying to get his testimony in by way of questioning for Mr. Richter. We're going through the same thing, which I think is now going to subject Mr. Bride to cross-examination.
I'm not sure I understand.
You're asking him about conversations between the two of you trying to get testimony about this case.
Right.
I think that's going to open up, subject you to cross-examination in this case.
I'm not testifying. You told me I could. And you said that I might call the other parties of the conversation, which is what I'm doing.
How is this relevant? Let's start there. What's the relevance of all of this?
What conversations you've had with Mr. Richter, where's the relevance to that?
Well, the relevance is the executive director suggested that it was appropriate not to report a debt that you hadn't
That's
received
testimony, it's testimony.
an invoice for.
Still, how is that relevant?
We're the decision makers, not Mr. Richter.
I understand. The relevance of that is not that it's binding upon you. The relevance of that is the reasonableness of Alan Freeman's campaign's conduct.
Well, at the stage you had a conversation with Mr. Richter, I presume he didn't have all of these trial exhibits and all the information that we've just gone through in hours and hours of hearings.
And I also, from my perspective, you're talking about your fact gathering to render a legal opinion to your client, which at that point in time, we're just talking about legal advice. So I'm having a hard time still with the relevance. How's that relevant to what your client knew or didn't know when we're not talking about your legal advice to him and whatever you did to formulate that, your opinion as to what advice you might get?
I understand that, you know, obviously that we need to be connected through the knowledge that the client had later on. But
Which is gonna be based on what his attorney's advising him, given where you're going with this,
Well, it might end up there.
which is then a question of privilege and waiver.
It would be a question of privilege and waiver, except for the fact that the affidavit, which we did not introduce, of my client, has already been introduced by the relator. The relator presented that as part of his evidence and was admitted. And that affidavit indicates, you know, that information, tying it up.
And you didn't object to it.
I did not object to it, it wasn't my place to.
Yeah.
I didn't introduce it, didn't object to it, but you're right. It's in evidence, for better and for worse.
I still don't understand the relevance.
Of Mr. Richter's testimony.
Right.
I agree.
Well, I think we pretty much covered it. I'd like to do the last question to make sure. Mr. Richter, did you just say it was reasonable not to report anything until the bill was received?
Based on your question, yes. My understanding of the statute is a campaign committee reports bills that it has received in its campaign finance report. And if it hasn't received a billing for anything, it doesn't have an obligation to list anything that it has, for which it has not received a bill. It's always been my understanding.
That's all I have.
Like to cross-examine?
Only like 2 questions.
No subpart is no question.
That's it. So, Mr.
Everybody always says two, and then I answer about 10.
Yes.
on my telephone.
Quickly.
But
I
anyway,
believe that Mr. Bry indicated that call was sometime in July, of July of 2020.
Yeah, it was in 2020. It was before your complaint was filed, but it was somewhere around the time that, as he indicated, the whole situation with regard to the householder folks had gone forward. I don't remember specifically when, but around that time, yeah.
Okay, when he had that conversation with you, did he disclose that the campaign had received a $290,000 bill
No.
from Content dated April of
No.
20?
No.
So 2020?
No.
So he withheld that information?
Gentlemen, we need to make sure that we finish the
sorry.
question and the witness then
My
answers.
apologies.
Otherwise, Sadie can't get it down. Thank you.
Do better.
He didn't indicate to me who the client was. He didn't indicate any other circumstance like that.
Okay, so he did not indicate to you that the client already had received a $290,000 bill?
He didn't indicate to me who the client was, so.
Okay,
No.
and so he did not provide you with any physical information that the campaign already had, such as that bill?
No,
Just a verbal conversation?
right.
Okay, was there follow-up to it after that? Did he come back to you, and at what point did he come back to you at all?
I don't recall there ever being a follow-up, as you say it, no.
Okay, that's all I have.
Nothing further from Mr. Richter.
Your next witness, Mr. Bry.
I'm going to call Alan Freeman.
And Mr. Freeman, if you'd like to take the chair right where Mr. Bry is, we can all see you there, that's fine.
You stole my chair.
Sorry.
I don't get the chair.
My bad.
It's all gone. Thank you. Mr. Freeman, when did you first have discussions about becoming a candidate in the 2020 election cycle?
I think we probably start, can you hear me okay? I've got a bit of laryngitis, so if you,
We can hear you.
okay.
Thank you.
I think we started having conversations sometime in June or July of 2019.
Did you meet with Anna Lippincott at any time about your campaign?
Not during that point, but after I was selected as the the candidate, and we did have a meeting with Anna, Megan Fitzmartin was there, Tommy Rolfe, and I think that was about it.
Would you take a look at Exhibit J of the Freeman trial exhibit number?
Yes.
What is that?
It appears to be a business card, one of which was handed to me by Anna Lippencock.
And who did she hold herself out as representing?
JPL and Associates.
Did you know who Constant Content was at the time?
Not at all.
Did you ever know who Constant Content was before the complaint you received from Mr. Hicks?
Not at all.
Did JPL discuss what they would be doing for your campaign?
They outlined various activities and responsibilities. Essentially, they talked about how they were going to do, they were going to essentially be a campaign team that would support our campaign.
Would you take a look at Exhibit K and tell me what that is?
Yeah, this is the list of items that they said that they would provide as services to my campaign.
Is there anything in Exhibit K that gives them authority to run broadcast ads?
Nothing.
Is there anything in Exhibit K or any of your conversations that gave them authority to spend money to campaign for radio or TV ads?
There's none.
When did you designate Susan Jones as treasurer for the campaign committee?
That probably would have been, I announced my candidacy on November the 25th of 2019, so sometime in November.
And did you tell her to provide real-time information to JPL about how much money was in the campaign committee or not?
Yes, I did.
When was the primary originally supposed to take place?
It's kind of interesting nowadays, I don't remember. March, I think the 3rd or 4th or 8th or something, or early March.
And do you recall that being extended?
Yes,
And do you recall when it was extended to?
April the 28th, I remember that vividly.
What were you doing between the time you designated Susan Jones as your treasurer and the primary?
Well, we were running a campaign. I was doing traditional campaign activities, putting up yard signs, making telephone calls, knocking on doors, going full bore.
Did you also participate in having creative radio and TV ads?
Yeah, I would receive emails and or texts usually from Megan Fitzmartin, that would show a piece of mail that was basically, I was just looking at the creative part of it.
And you take a look at Exhibit W. Well, before we go there, you knew that ads were running during your campaign period, did you not?
Yes, but there were at the time, there were TV commercials that were, coming from another source that were out there as well.
Did you know the amount
Do I know the amount?
that was spent on broadcast?
I did not.
Did you expect to approve the amount?
I did.
I showed you what's been marked as Exhibit W. Can you tell me what that is?
Exhibit W appears to be an invoice from Constant Content.
And I note that it's addressed to Alan Freeman as well as to Susan Jones. You see that at the top of Exhibit W?
I do.
Do you have any record of having actually received Exhibit W in 2020?
I did not.
Do you know whether or not this email ever came through on your email?
I never saw it.
When was the first time you ever saw Exhibit W?
I saw Exhibit W probably sometime March or April of 2021.
And how did you come to see it?
We were discussing, we being Susan Jones.
Susan Jones,
Yes. And she said, oh, I remember there was an email, which I was surprised about.
did Susan Jones also tell you that she was told that this was an erroneous email?
Yes.
And did she also tell you at the March, April 2021 time that this was not something that the campaign ever reported or needed to?
Yes.
At that time, did you know that there was an attachment to Exhibit W?
At that time, all I had was basically what you see here, which is just basically the static document.
When did you first learn that there was some kind of attachment to Exhibit W?
Surprisingly enough, it was at the last hearing.
And have you ever looked at the attachment?
I have.
And when did you first look at the attachment?
I believe it was Monday or Tuesday of this week. This week.
And how did you get the attachment?
Susan Jones sent it to me.
Would you take a look at what's been marked as Exhibit X? I apologize. You have it?
Actually, I don't have it.
Oh, he's got it, you don't.
It's not in our notebook.
Yeah, and I apologize, I have copies of this and I forgot to.
By the way, I think you took my notebook, and this is the notebook that you have that has extra things in it that I never.
Okay.
Did somebody check whether this was actually in the exhibit submission?
Exhibit X was not an exhibit submission. And if he wants to object on that basis, he can. I just figured if the commission wants to know what the attachment looked like, we could introduce it.
But you had it in a notebook?
No, I put it in a notebook since the last exhibit.
Oh, so you're adding something to
I
that?
would be adding something that was not originally disclosed,
Why didn't you disclose it to me before now?
because I didn't know it existed until 3 weeks ago.
Why didn't you disclose it to me 3 weeks ago?
Are you allowed to have that back and forth? Honestly, and like.
You know, I don't care. If he doesn't want us to talk about it, we won't talk about it. If he wants us to talk about it, we can introduce it.
Well, in fairness, you should have provided to them well before the hearing date. You've known its existence for 3 weeks. At least your client to testify, you learned about it 3 weeks ago.
Well, actually, for a week and a half of that, I was home in bed with COVID. And I decided earlier this week that this might be something that we would use today. I mean, but if you want to exclude it, let's just exclude it.
No, I don't object. But I don't have a copy either, because the notebook I have doesn't have a copy.
I understand, I should have made more copies, I thought I had.
Can I get a copy?
Eventually I need one, but no, give them, make sure everybody else has one before me, and then you and the witness does.
Okay, is this 2 pages done? I think I got two.
Oh, it is just one here.
If I need, I don't look over hers or our shoulders, I just,
Would you take a look at what's been attached as Exhibit X?
Sure.
Is this the attachment that we've been talking about?
Correct. It is.
Okay, we'll follow up with some more questions about that later, but I want to get through the rest of the timeline first. Well, let's back up. After looking at this Exhibit X, does that give you reason to question whether or not the Exhibit W was a legitimate bid of the campaign?
Yes.
How so?
Well, a couple of different things. I mean, if I had seen this at the time that Susan received it, I would have agreed with her to reject this bill, this invoice. First of all, it came from Constant Content, a company I had no clue who they were, and how they were related to my campaign. Furthermore, there are items in this list that are incorrect and they didn't perform. Then finally, with regard to some of the larger numbers, there's no backup material to show what it is that they performed or any airtime that they said broadcast airtime. Quantity 1. I don't know what that is. There's no detail that would tell me exactly what I'm spending my money on or what I'd spent my money on. So I would have rejected this out of hand, which is, as I understand it, one of the 3 things that a campaign can do, which is 1, if you get a bill, pay it, which is reportable. 2, reject it and require them to come back with a better answer. Or 3, negotiate it. And I would have rejected this out of hand if I'd seen it back in April.
Were there any attachments of invoices to any TV station or by any TV station?
There were not.
Were there any attachments of invoices to or from any printing company or video production company?
There are not.
Did anyone have authority to spend 6 figures or anything close to it without your authorization?
Certainly not. The only other thing I would add is when you're looking at the broadcast airtime at 104,500, it's far more than this campaign would have ever needed.
On April 28, 2020, that was the new primary date?
Can you repeat that?
April 28, 2020,
Correct. It is.
and I think it's been testified that you lost the primary.
I did.
After that, did you do anything to try to make sure that whatever debts the campaign had were known and paid and reported?
Well, I reached out to the campaign, the folks that I was working with through JPL, which means primarily Megan Fitzmartin, Stephen Caraway. They continually told me to reach out to Anna Lippincott because she's the one who would handle this sort of thing with billing. And so I did. I tried to reach out to her. I gave her a call, but she did not return my call.
And did you use the number that she had on her business card, Exhibit J, or did you use a different?
I used that number.
Did you also contact Susan Jones and ask her to try to track down?
I did. We had a conversation shortly after the election, wherein I asked her that, she said that she could reach out to Anna Lippincott and see what she could get back. I asked her to do so, and I did not hear back from Susan on that front.
Did you leave a voice message with Anna Lippincott? Did you ask her for the 5 invoices?
I did.
And did you ever receive a response?
I did not.
Do you recall when the householder folks were all indicted and had the record seized?
I do.
Had anyone sent you an invoice or other backup information prior to that happening?
No.
And that I believe was around July 22 of last year.
Yeah, I believe so.
Did you consider it feasible or unfeasible to try to get additional records from the U.S. Attorney on what they had financially that was spent, authorized or not, by the folks that they had just indicted?
I did not.
And again, you just heard the testimony of Phil Richter about a conversation I had with him,
Yes.
right? Do you also think it was reasonable not to report anything without an invoice?
Well, at the time, I mean, I had no way of knowing what to do. I mean, it was fairly unique. Amongst campaigns that I've been on, I've never had a campaign where the consulting firm that we hired or utilizing have been basically arrested.
Oh, I don't know.
When did you first receive notice of the Hicksley Freeman?
Probably sometime in September, October timeframe of 2020.
And when did you first learn of strategic invoices to, or strategy groups invoices to constant contact?
Probably sometime in the beginning of 2021 in connection to these hearings.
And have you, prior to, was that shortly before the amendment was made with the Secretary of State's office?
It was before that.
And I believe if you take a look at Exhibit I, it looks to me like the first page says the amendment was submitted April 15, 2021. You see that? Date right under the report submitted paragraph.
Yeah, what date did you?
Date submitted 4-15-2021 at 3:44 p.m.
Correct, I see that.
Aye. And if you flip through, let me see how many pages. 1, 2, 3, 4, 5, 6, 7, 8, 9. I think at page 10, if I'm kind of correct, there's a one-page all caps related to left column Freeman and an explanation. You see that?
I do, yes.
Did you review and approve that explanation?
I did.
Have you or your campaign received any further communications from the Secretary of State's office suggesting in any way that this explanation was inadequate?
I have not.
Do you understand or do you not understand that the Secretary of State's office actually audits reports from time to time?
I do.
And you see the third paragraph down where it says on Friday, April 9th for the first time, council received the attached invoices from strategic media replacement to constant content totaling $137,982.81 for advertising for Freeman Allen. We did not previously see these invoices, nor did we receive anything from JPL Associates or anyone else claiming to owe all probably none of these invoices. Whatever council received, is that around the time you first saw those invoices?
Yeah, I think so.
And is it also true that you had not previously seen those invoices?
Yes.
And that you had not received anything from JPL or anyone else claiming you owe all part or none of those invoices?
Yes.
Did you ever receive, or did your campaign ever receive any information from anyone notifying your campaign committee that the strategic meeting invoices had or had not been paid by a third party?
I did not.
Have you or your campaign ever received any information that the strategic meeting invoices had been made via an in-kind contribution to your campaign?
I did not.
As you sit here today, do you know whether or not some, all, or none of the $137,982.81 was in fact legitimate approved advertisements for your campaign committee rather than something else?
I do not.
Just to clarify, JPL never sent you or your campaign committee invoice for this amount from strategic. These are strategy.
JPL did not.
believe in addition to leaving a telephone message for Anna Lippincott to call you back, you also had conversations with Stevie Caraway and with some other folks who said she's the person to talk to.
Correct.
Did Stevie Caraway ever say you owe everything that was in the $290,000?
No, Stevie Caraway did not mention any dollar amount. He suggested that he knew that there was a debt, but he did not indicate what that debt amount would be. And that's why he suggested that I reach out to Anna Lippincott, because Anna would have all the details on that. It wasn't his bailiwick during the campaign or otherwise.
Did Stephen Caraway also tell you that he knew that significant portions of money that was spent on the campaign were not obligations of the Alan Freeman?
Objection, hearsay evidence.
It is.
It is, I think there's an exception.
Sustained?
So I can't answer the question?
You're asking what Caraway said?
Yes, I am.
No, it's hearsay.
Caraway is a representative of Constant Contact.
Caraway was called to testify, wasn't he?
He was called to testify. That doesn't mean that his statement can't still be used as to what was owed to Constant Contact or JPO or somebody else, and then saying that you don't know all this stuff. That may be technically hearsay, but it's often not for the truth of the fact, but the fact that it was stated to him. In other words, Mr. Hicks is saying he should have known that he owed this money. And
Here comes
Mr. Caraway said you
testimony.
don't.
I think it's hearsay. I'm going to sustain the objection.
It's only, okay. The hearsay would only be if it's offered for the truth of the statement.
Maybe I'm wrong. Move along.
Did you have an understanding, not just from Susan Jones, that you did know all the money that was spent in your campaign?
Yes, I mean, that was my understanding that I did.
And where did you get that understanding?
Well, I mean, we had the agreement that everything that was in the account would, as you stated, would be in real time. The campaign would see how much money was in the account, and that was the kind of the firewall. Added to it, I felt that I should be responsible for approving expenditures, and clearly I would not.
Did you ever authorize JPO or anyone to spend or incur debts of the campaign beyond what was in the campaign's campaign?
I did not.
Did you expect that you would personally approve any of the campaign debts?
Yes.
Did anyone ever have authority to spend six figures or anything close to it without your authorization?
No.
Do you know who ultimately paid for all of the advertisements that had your campaign's disclaimer?
I do not.
Do you know whether or not some, all, or none of those expenditures are in fact proper debts of the campaign?
I do not.
Do you know whether some, all, or none of those expenditures were in-kind contributions from a third party?
I do not.
Do you know whether some, all, or none of those contributions were unauthorized expenditures for which the campaign has no liability and no reporting duty?
I do not.
Do you know why the JPO folks never provided adequate information so that you would know that?
I don't.
Do you know why neither Anna Lippincott or anybody else from JPO ever contacted you with additional information?
I don't.
Do you know whether whoever currently represents Constant Contact has ever offered to provide additional information?
No one has.
I think that's all I have for now.
Mr. Hicks?
So there's a stack of exhibits here that are my exhibits on.
Mhm.
So you might want to sit here so you can access them easy. Go through. I want you to look at exhibits when I tell you to look at
Well,
specific exhibits. So. Okay, can you describe for me, Mr. Freeman, your background in politics?
I've been active in politics for quite a few years. I've been in a number of campaigns, and I tend to do grassroots activities for campaigns throughout the last probably 20 years.
Can you list out people that you have worked for in the political world?
I'm sure I can.
Proceed.
I've worked for Senator Portman when he was a congressman. I've worked for, campaigned for myself. Campaigned for dozens of candidates on the local level, from judicial races on down to county commission races.
What about Bob Taft? Did you work for Bob Taft?
Sure, I worked for Bob Taft.
Did you work for Gene Schmidt?
Yeah.
How come you didn't list those when I asked you to list out your?
I object to the form of the question. He didn't say it was listed in curriculum vitae. Wholly apart from the relevance of the question anyways, back with if anything else. Okay, so we'll start off with 1978. I worked for the Reagan campaign. Moving forward, I worked for, in 1986, the Jim Rhodes campaign as a volunteer. Forward, I worked for Bob Taft in 1990. I also did work for George Voinovich when he ran for Senate against Howard Metzenbaum. Let's see.
I don't mean to interrupt, but let's get to some relevance here. I mean, he's been in politics for a long time. Let's move on to something that has bearing with why we're here.
Okay, so then you would set it up, you would say that you have a lot of political experience,
Yeah, political experience.
okay, including a lot of paid political experience,
Yeah.
okay? And have you ever filed a complaint to the Ohio Election Commission yourself?
I don't think so.
So, if I told you that, if I put one up here, would you? So, you filed a complaint against Bob McEwen?
Oh, well, yes, I remember that. During the Schmidt campaign, there was a volley back and forth between the campaigns, filing ethics complaints left and right.
Okay. What was your relationship on the campaign with R.J. Mancini?
RJ was he was a person that came down from Columbus. He did a lot of door-to-door as he testified, and that was about it.
Is there a reason why you did not disclose him on any campaign finance report as an in-kind contribution?
As I recall, there was never any paperwork that had been presented to me anyway regarding how that was happening. So I didn't receive anything, so therefore I didn't report it.
Did you ask for anything?
I did not.
Okay, so, okay. What about Luke Householder? What's your relationship with Luke Householder?
Luke Householder appeared in the campaign and then disappeared.
Describe for me what you mean by appeared and disappeared.
Well, he came in, was with us for about a week and a half, knocked on doors. I saw him twice, and that was the end of it.
Well, based on my video with Luke Householder, he was in the district for at least 3 weeks. So, but you're saying he appeared and disappeared. Can you explain more
I would
where he
object to
was
the
or wasn't
premise.
there?
I would object to the premise, Mr. Hicks is not testifying, you should ask the question directly.
Is there a question there, Mr. Hicks?
Yes, if I told you that I personally, through personal knowledge, knew Luke Householder was in the district for at least 3 weeks working for you, would you dispute that?
I would object to the premise. Again, he's trying to testify in the form of a question. He can ask whether he was there 3 weeks. He can't premise it by saying, since I know this, are you going to dispute it? That's trying to testify to a question.
Overruled. Go ahead, Mr. Freeman.
Actually, I probably would dispute it, because I only saw him twice. I have no clue what he did for 3 weeks.
Okay, did you have a Facebook post showing Luke Householder with you going door knocking?
That was one of 2 days,
Okay,
as
and those-
mentioned before.
there was testimony that he attended at least one of your campaign meetings. Do you remember that?
Yes, I do. That was the second time.
Okay, was that one day after another?
No,
Was it in the same week?
it was about the same week, yes.
Okay. Can you look at Exhibit 2 in the stack that I have here? So my exhibit's Exhibit 2.
Is this for the revised exhibit or from the original exhibit?
It's from my exhibit's Exhibit 2.
You have two listed. One is the revised exhibits, and one is
There's
the...
no revisions to the exhibits, Don. I provided you with a subset to say I don't think I was going to use the rest of
Okay.
them. So the constant trying to interject that they were revised in some way, as a courtesy, I showed you that I was only going to use about half of them from.
I appreciate that. The reason I state that is in the original, some of the exhibits also have PowerPoints that are not actually documents. And I want to make sure I was looking at it correctly.
Mr. Hicks, you've indicated there's Exhibit 2, but I've got 2 books that say 2.
Is it the affidavit?
Exhibit 2 is my original affidavit. from when I
Thank you.
submitted.
With a lot of papers.
If you flip back it to Exhibit 2, to the 4th page, actually says page 3 at the bottom. If you I have a title page, it's page 3 at the bottom. But then like what I handed to you, Mr. Freeman, it has a title, page, that's not numbered. So, what is that image of?
If I'm looking at the same thing you want, you're suggesting what you want me to look at. It's a picture of me.
Okay, on where?
Excuse me?
Where?
It's on what appears to be JPL's, I guess their webpage.
Okay. Did you give them permission to use your image on their webpage?
Maybe not,
Were you aware of them using your image on their
not
webpage?
until you showed it on your Facebook page.
Okay. So, that's the only time you became aware of that you were being featured on JPL's website?
Correct.
Was at that time? Okay, did you ask them to remove your picture once you found out?
It seemed irrelevant, so therefore I did not.
Okay. Why don't we flip to exhibit number 3 in my book, so it's Alan Freeman's original affidavit.
Yes?
Okay. In your mind, what's the difference between Constant Content and JPL and Associates to you?
I have no clue.
Did you ever ask anybody?
I never heard of I never heard of Constant Content until these proceedings.
When you received things through Dropbox that said they were from Megan Fitzmartin at Constant Content, did you not question what that meant?
I actually just opened it and never realized that it said Constant Content.
Okay. Okay. So looking at your original affidavit, Exhibit 3,
Yes?
it says, point number 5, the committee contracted with JPL Associates to provide media services.
Yeah, I view that as a verbal contract.
So there was no written contract.
Correct.
Okay, and then if you look in Mr. Fry's exhibits, at Exhibit K, I think it was. The reason why I'm you put the foot down. So, in Mr. Fry's exhibits, what is Exhibit K?
This was just what they presented at the initial meeting as things that they would do for the campaign.
So, what, but this was not in your mind a contract?
Again, I said verbal. This is what they said they would do for the campaign. Therefore,
And you're saying this is what you agreed with them to do for the campaign?
right.
So why then later were you working with, in your mind, who were you working with in your mind when you were filming TV commercials?
Essentially, it was the subcontractor, which would have been Scottsville Schweitzer's company,
Who was he subcontracting to?
JPL.
This exhibit K, is there anywhere on there where it says making commercials or doing media?
No, it did not.
So your representation is exhibit K is the services they were providing, but you were filming commercials with them.
Yes.
Why did you think you were filming commercials with them if they weren't providing the services?
Largely because they were organizing the shoots. And I was utilizing Caraway and others as part of the effort, setting up the site, the locations, and that sort of thing.
But what? So you were filming TV commercials just because people were setting it up for you to do it, so you just went?
Now, Chris, it's part of the campaign. You know, people do television commercials as part of the campaign, and so you work with professionals who will help create that creative.
Well, who had you contracted with to do commercials for you?
Essentially, JPL expanded into that role.
Do you have any contract or evidence of that?
I don't.
So other people testified, such as Stephen Caraway, that the bills went through Constant Content, including his own bills went through Constant Content, including a bill that I believe you were copied on email from Stephen Caraway. Did you not notice that Stephen Caraway was billing Constant Content for expenses?
I believe, if I remember his testimony correctly, he indicated himself that he didn't even know when he was billing Constant Content and when he was billing JPL. So there's no way that I could have known how and in what manner he was billing anybody.
And I think he testified that his expense invoices said Constant Content, and the actual expense invoice that he provided was to Constant Content.
Again, I would not have seen what his agreement is.
So I'm not asking you to testify to him, but you're saying you didn't notice that he was sending expense invoices to Constant Content.
Oh, no, I wouldn't have seen it.
Okay. All right, let's go on to point 6. As part of the services JPL was to provide commercial time is approved by me. Did you ever approve any commercial time in your mind?
In my mind, and in fact, I did not.
You did not approve any commercial time.
No airtime.
You were aware that commercials were running?
Vaguely, I did see the other commercials frequently, but you gotta remember, Chris, I was on a campaign, so I was out knocking on doors. I wasn't sitting at home watching television.
What were the other commercials you keep referring to?
That was the I don't know what the name of the organization was called, but it's Growth and Opportunity Act. Commercials were running at the same time.
When do you think you became aware that commercials were running with your disclaimer on them?
I don't know a specific time.
March, April 2020?
Yeah, it would have been 2020, when it was March or April. It would have been before April because of the fact that we had changed the date of the election, so probably would have been late February.
When you became aware of these ads running, what did you do?
I just reached out to the campaign, said that I'd like to know what the timing was, and I never received any response.
When you say you reached out to the campaign, who specifically did you reach out to?
I reached out, I called Megan Fitzmark.
Okay. She never responded to you?
She said she was going to get back to me and never did. But that's not uncommon because as the campaign progresses, a lot of things happen that you have to move on to something else.
So I think she testified that during the heat of the campaign, she talked to you almost daily.
I think that's true.
So you didn't keep bringing it up? when you knew there were commercials running?
There were 1,000 things going on at the same time, and, you know, we were trying to run a campaign that we started in November that should have started maybe a year before. So we had a lot of details flying at the same time. So, you know, in that fog, sometimes you miss a detail and you move on, and something else comes up and you have to react to it.
Okay, so did you ever request to anybody to try to stop the commercials?
No.
Why not?
First of all, again, we moved on to other things. Second of all, the TV commercials were running, and I had no idea what the rotation was, and how many TV commercials were out there. So I
Did
did
you
not.
contact any television station
Why would I do
to ask them who had placed this advertising?
that? No, I did not.
Why not?
It was irrelevant.
It was irrelevant.
Right. We didn't I mean, we're not disputing the TV commercials ran. I knew the TV commercials ran, but the point of, you know, how much of the TV was running, I did not have that something.
I think we're disputing whether you filed a complete and accurate campaign finance report.
Correct.
So, okay. The Scott Schweitzer testified that you and he have been friends for 12 years, worked on many campaigns together. Was he present when you filmed the TV commercials?
Yes, he said.
When they started running, did you contact your friend Scott Schweitzer to ask him about them?
I did not handle creative.
So, why didn't you contact him?
I didn't contact him because it was irrelevant. I mean, we were running television commercials, and, you know, it would have been done by our, you know, by JPL.
You just said, your own words, we were running television commercials.
Yes.
So at what point in time did you get, I'm gonna ask a different question. Other people testified, including Stephen Caraway, that they knew the commercials were coming before they went on the air. Did you know the commercials were coming before they went on the air?
I did not.
Okay. That's your testimony, you did not know?
In fact, I'll go further to say that I noticed the TV commercials because people commented to me, my friends and others, saying that they saw the TV commercials.
What about the radio ads?
I never heard them.
You never heard them?
Correct.
Didn't you hear them here?
I did hear them here, but you're asking during the campaign. During the campaign, I didn't hear them during the campaign. But here, I did.
I want to have you look at my original exhibit 2 again, and we're going to come back to your affidavit. But I want you to go into exhibit 2. I'll need, because I don't see it here. Did you make a Facebook post about your TV commercial?
Mhm.
In that Facebook post, did you make some statement to the effect that if you haven't seen these yet, here's my latest TV commercial?
Yeah, pretty common statement.
So that you made that statement in a Facebook post for commercials that you did not authorize running?
Again, let's clarify, I authorized the creative, which I had seen, and I signed off on. I did not approve the purchase, the buy, the television buy.
But you made a Facebook post saying, in case you haven't seen it yet, here's my latest, something to the effect of, in case you haven't seen it yet, here's my new TV commercial.
Yeah, pretty common to try to get extra traction on a television commercial, using it for social media.
But in your mind, based on your testimony, it wouldn't have been a television commercial because you never authorized it to run on television. It would have only been a social media commercial.
No, it was a television commercial. Again, I'm not suggesting that TV commercials didn't run, we did.
And when they did run, you took no step to find out who had paid for them at that time or to stop them because they had not been authorized.
No, because the guardrail was set up, that if there's an amount that needs to be paid, then that my treasurer will bring that bill to me and I'll approve it. I did not approve that TV commercial would run in a larger rotation than would be expected.
So there was a guardrail where you would see things like TV commercials running, but unless your treasurer who lived in Columbus reported that to you, you would not take any action.
No, that isn't what I said at all. What I'm saying is that when the bill arrived, then the treasurer would contact me to get approval. She was not watching for the media to show up. She was watching for the bills to show up.
Okay. Let's go back to your affidavit, item number 7 in your affidavit, which in my things I think is to the 3. I'm looking at item 7. I did not approve all the bookings and documents attached to the complaint. At this point in time, do you dispute that those things that were attached to the complaint were ads for you for your campaign and involved with your campaign? Not involved with your campaign, but do you dispute that those ads ran or not?
I would object to the form of the question because I think it's kind of ambiguous. What he's saying, if he's asking whether the ads ran or not, whether he knows or doesn't know, that's
Let me
fine.
rephrase my question.
Perfect, thank you.
Do you question the legitimacy of any of those invoices that were provided in my complaint?
Yes, I mean, I can't possibly know whether or not the specific television commercial ran at a specific time. The only thing that we have there is that television commercials were booked, but not necessarily the fact. Even Scott Schweitzer pointed out that sometimes they don't run, and refunds are offered from the television stations because the commercial doesn't actually run. So I can't tell you with any certainty that every radio station and television station that you contacted and sent back that information, I can't guarantee you that it actually ran.
So a few minutes ago, you testified that Scott Schweitzer, you didn't contact him about the invoices because he was creative and not invoices.
Right.
But now you just testified that Scott Schweitzer dealt with refunds.
No, what I testified to is what he testified to because he has that experience. He said that here.
Okay. When you made your April 15th filing to the Secretary of State, you included invoices as part of that, not the new exhibit X that Mr. Bry brought forward today. The invoices that you included with that filing, where did those come from?
The $138,000 came from these proceedings, and then the $290,000 came from what Susan Jones provided.
Okay. The $138,000 worth of strategy group invoices, do you dispute that any of that those were for media placements and execution that contained your disclaimer?
I can't be sure.
Have you, I think we got those a long time ago, have you investigated that?
I have not.
Why not?
At a certain point, we appear in these proceedings.
Do you think that you have a duty as a candidate to use reasonable diligence when it comes to providing accurate campaign finance reports?
Well, I think you do, and I think this is illustrated by what we've been discussing in these proceedings. I mean, the truth of the matter is I think what you're getting at here, Chris, is that I should have gone around to every one of the TV stations and radio stations and done, the homework that you did. But the problem with that is that doesn't even give me an adequate number. As I said before, and Scott Schweitzer backed up in his testimony, those TV commercials may or may not have run. The TV commercials were items that were an expense, but the truth of the matter is if I can't tell you how many TV commercials ran and add to it if there's any kind of markup associated from JPL or anybody else inside the bill, am I giving the commission an adequate number? And I would tell you I'm not. And so we'd be right back here with you saying that I didn't give adequate numbers if JPL in fact provided a bill that was different from what my research would be. So the point is, I'm opening myself up for danger by providing data that may or may not be complete. And so, once again, as Mr. Bry has pointed out, inventing a number.
When you made your April 15th filing to the Secretary of State, Did you contact your friend Scott Schweitzer before you included his invoices to ask him if there were any adjustments to those invoices?
I did not.
Why not?
Again, I just told you.
Okay. Let's jump down to item number 11 in your original affidavit. On or about April 30th, 2020, I asked my treasurer, Susan Jones, to contact JPL to obtain final invoice for review and payment. She was unsuccessful. Is that a truthful statement?
Yes.
She testified that that didn't happen. Can you explain why you would have a different view?
I would object. He's mischaracterizing the testimony. She said she did not recall and that it could have happened, is my recollection.
I think he can answer overruled.
I can't speak for her.
So the invoice that you received from Constant Content, that you say you, I guess you looked at some point in time, but from my recollection, it was dated April 1, 2020, the email. The invoice itself was dated March 18, 2020. When on, to your affidavit, when on April 30th, 2020, you asked Susan Jones to go get an invoice, was did any part of that discussion raise that she had received an invoice
No,
about 30 days earlier on April 1st?
no, she didn't bring it up.
When she said here that she said that she really didn't distinguish between Constant Content and JPL because it was the same people. So I guess I just want to clarify, you're saying that when you had a how did you tell her on April 30th to go seek an invoice? Was it a discussion? Was it an email? Was it?
It was part of a larger discussion.
Okay. And in that larger discussion, neither you nor she brought up that there would have been an April 1st invoice. You, because you would claim, based on your testimony, you never saw it in your email. And her, okay, so it never came up in that discussion. Did she ever get back to you?
She did not, because and I didn't follow up with her simply because I was already trying to get to the bottom of it myself.
What were you doing to get to the bottom of it yourself?
I tried to contact Anna Lippincott. I reached out to Megan Fitzmartin. I also reached out to Caraway, as I testified to before.
So let's break this down. Megan Fitzmartin, what happened when you tried to reach out to her?
About 2 weeks later, she called me back, said, talk to Anna Lippincott.
When did that take place?
Approximately 2 weeks after I placed the first call to her, and I don't remember the date.
In the first primary, second, April, May?
It would have been May. The primary was already over, and I was trying to wrap up. Quite frankly, it was probably a moment in my life I just wanted to get cleaned up, moved on, and get over with.
So when did the primary end?
Hasn't yet.
When did the voting end in the primary?
That was a joke, Chris. The voting ended approximately April the 28th.
Because approximately.
Well, because remember, you also have, once the election is held, you have provisional ballots that have to be counted, you have any challenges that may come up, so it is approximate.
Okay. So when then was the election certified about you?
About 2 weeks later.
About 2 weeks later?
I would leave that up to the Secretary of State's office.
So that would be in sometime in May
Sometime in May.
that the election would be certified. So when, sorry if I'm being redundant, when do you think that you contacted Megan Fitzmartin about the?
Again, sometime in May. I mean, it was pretty clear on the 28th that I'd lost. So there was no point in me waiting for the provisional ballots
Okay.
or anything else to be counted.
And you're saying she did not respond to you?
She did not.
Was that normal or abnormal?
It was abnormal, but again, I think testimony here, I was trying to come up with a funny kind of glib answer. I was a dead man walking. I was done. They were moving on to the next election. They testified to that here.
So Stephen Caraway testified as to discussions with Anna Lippincott and, in fact, with you about the need to raise money to pay off your bills. Do you deny those discussions or agree that those discussions?
I agree
took
that
place?
they took place.
So how much about total did your campaign report on its campaign finance reports that it spent?
I believe, I think you continually say about 14 to 15,000.
So, before I go to the next question, it's also been described that there was a real-time mechanism to keep track of how much money was in the campaign account so that there wouldn't be approvals, or expenses beyond the scope of the campaign account. Correct?
Correct.
So how much money did you still have in your campaign account at the end of the campaign?
Approximately $96,000 in change.
So is $14,000 the only amount you ever authorized to be spent for your campaign?
Yes,
Okay, so why were you worried about constant feedback loop on the status of your campaign financially if you had way more money than you were ever going to authorize spending?
well, the truth of the matter was that Caraway had indicated that there was a debt, and I wanted to get it cleaned up.
What debt?
Again, he never gave a number or characterization of what it was exactly for. So I had no idea what it was, but my contact point was Anna Lippincott. She would be the one that I'd work with to try to resolve the issues. And that's what I was trying to do.
Mr. Caraway testified that there were discussions about needing to fundraise using the speaker's team to pay off your debt. Were you involved in those conversations?
I was in the conversations with Stephen. Stephen mentioned that it was not uncommon for the speaker's office to do additional fundraising post-election.
Why would you be engaged in any conversations about paying off your debt if you had $96,000 in the bank and only had $14,000 in expenses?
Because Mr. Caraway was indicating that there was debt, and I wanted to make sure that we cleaned up everything so we could close the books and move on.
And so what became of those conversations?
They ended.
Why?
At some point, the householder team was arrested, and the speaker's office was the office of the group that we were dealing with disappeared.
Well, let's be clear on that, though. The primary ended in early May when the provisionals were done. When were people indicted?
July.
Early July or late July?
I believe the date on our, that we discussed is July the 22nd. But you gotta remember, just because they were indicted on the 22nd doesn't mean that their books hadn't been seized before that.
Well, when did you have to file your campaign finance report for the 2020 primary?
I don't know, sometime I believe in June.
If I told you it was filed on June 5th, would you have any reason to dispute that?
I have no reason to dispute that.
So how far in advance of anybody being indicted is June 5th?
It's quite a bit, but the point is that our books had to be reported, our expenditures had to be reported before June 5th. So it was everything that we had in our knowledge before June 5th.
So your campaign treasurer, Scott Schweitzer, testified that they were shocked when there were indictments, that it came as a surprise to them.
Yeah, I was surprised as well.
So your description that there was something to do with potentially things being seized, causing you to not be able to report stuff,
I'm not,
nobody would have been aware of that other than you?
no, I did not testify to that. What I simply said was, you asked when the indictments were. I said the 22nd, but that doesn't mean that their books and their offices hadn't been interrupted before that. You can't say.
Separate from what it says in your affidavit, did you have any conversations with your treasurer, Susan Jones, before filing the affidavit?
No.
Okay, okay. Did you have any, did you ask her to take a look at it before you filed it?
No.
Did you ask Megan Fitzmark to take a look at it before you filed it?
By that point, I had no contact with Megan Fitzmartin.
Did you ask Stephen Caraway to look at it before you filed it?
I did not.
So, without divulging anything that's attorney-client privilege, did anybody review, other than you, review this prior, and your counsel review this prior to you filing it?
That was it.
What was that?
That was it. It was just the two of us.
Okay. I'm gonna go on to 16, item number 16. On your affidavit, you said, I also do not know whether or not the ads listed in the attachments to the complaint were actually for another candidate, or whether or not there was any kind of contribution in a particular amount that my campaign committee was never notified of. What research did you do to develop your personal knowledge of that being a true statement?
The fact that, again, I don't know of any, none of those items were, that I have knowledge of. And the statement speaks for itself.
But before filing the affidavit, you took no steps to try to have more complete information before making that representation.
And what I can tell you is that even if I had, I wouldn't have been able to change that statement, correct? So as I stated before, had I called around every one of the TV stations, garnered all of that data that you brought forward, it still wouldn't have told me that. Because I don't know, I mean, from the JPL side, I couldn't possibly know what part was supposed to be an in-kind, what part was for somebody else. I could not have known from that data, just looking at the data.
Do you know A. Brant Fink?
I do not.
Have you heard that name before?
I have not.
So, it was testified to, A. Brant Fink is the person that did the FEC required disclosures to the FCC database about who had paid for campaign ads that Scott Schweitzer's firm was involved with. Have you seen from my
I
file?
would object and move to strike the testimony premise. If there's a question, you can ask it.
No.
No, that's, I mean, it's a lot of testimony, you could cross-examine on something if you, I don't know. I don't know where it's going.
I can rephrase the question to make it easier.
Yeah.
Okay, so this is,
Shorten the question.
so did you,
So we know what it's about.
did you see those disclaimers that were filed claiming that the campaign had paid for the ads? Did you see the FCC disclaimers claiming that, not the disclaimers on the ad, I'm talking about the documents that need to be filed,
Yep.
the legal documents that need to be filed with the campaign purpose?
No.
I'm sorry?
No.
No. Are you aware of what the rules are for TV ads running? Are you allowed to have, for example, credit on them, or do they have to be paid up front?
It was always my experience that they needed to be paid up front, except for when you're dealing with an organization like ORP or the ORCC, which I think is called something else now. But ORCC oftentimes will pay for campaigns that they endorse.
But they have to pay up front, right? And then they rebill
would
the
have.
people.
They
So
would have.
everybody has to pay up front, as far as you know. Okay? So when you saw the ads, did you know that somebody had to pay for these?
Yes, but again, ORCC has been known to front the commercial cost, and then you have to pay them back.
Okay.
And ORCC had, in theory, endorsed me because the Speaker's office had endorsed me.
Okay. Why did you, item number 18 on your affidavit, this is before I had filed anything, why did you seek Don Bry's legal counsel on July 30th?
I'm sorry,
What's the key to that date?
I would object to attorney-client privilege at this point. The affidavit's in, obviously.
Stay.
Okay. All right. In a lot of your emails, you were approving not media commercials, there was that, but also a lot of mailers.
Is that a yes, sir?
I'm sorry, that was a yes.
Thank you.
And what did you think was happening when you approved a mailer?
Well, I was approving the mailer. There was a point made by Megan Fitzmartin that I was approving mailers that may or may not go out. We were getting the approval so that we could move quickly if we wanted to.
Okay. Were you aware that mailers were in fact going out?
Yes.
I would like to play, I don't know if you're going to do this, but I'd like to play one of the video exhibits that I had. I'll identify here.
I would object on redundancy grounds. We've seen these videos over and over again.
Not the one I'm going to play?
Okay.
I don't think you want to. This was exhibit 26 in my video exhibits, exhibit 26.
And I think that is.
Unfortunately, I think it's the regrettable nature of politics these days, where the negative is what applies.
Sorry, John, did you want to say?
Yeah, I just said, just for your edification, that is in his original trial exhibits, and not in his revised trial exhibits. I don't know.
That's untrue. That's a false statement.
Well, here's, I believe it's
That's a false statement. Okay, okay, exhibit 26.
Unfortunately, I think it's the regrettable nature of politics these days, where the negative is what applies. You know, if you look at the direct mail pieces that I've put out, they have my disclaimer on it. They've all been positive. They've all talked about economic development. They've all talked about growth and opportunity. So that's where I continue to try to stay. I will tell you, gentlemen, I don't even mention your names when I'm out on the campaign trail.
Do you recognize that clip? Where did that take place?
There was a debate that took place in Brown County.
And you referred to the mail pieces that went out, and when you see my mail pieces, correct?
Yes.
But your testimony would be you never authorized the sending of any mail pieces?
I authorized the art, not the dollar amount spent.
So how would people have seen mail pieces that you talked about in a forum if you never authorized any spending to put them out?
Direct mail is different, but the truth is that direct mail was going out. Again, we never said that never happened.
But you have said you never authorized it.
The dollar amount I did not authorize.
What did you authorize?
Art.
So you never authorized any mail to actually be sent?
I authorized the art for it to be sent. The dollar amount I did not authorize. I'll say that again.
You were aware mail was going out?
Correct.
You talked about it in a campaign forum?
I did.
How did you think, who did you think was paying for it then?
Well, we had funds in our bank account. We were also trying to raise more money, and so that's what we do.
So hold on, you had funds in your bank account, but you never authorized it, so that would be, so who did you think was paying for it when it was being done?
At the moment, I had no idea.
What did you do to try to figure out afterwards who had paid for it?
I was running a campaign. I was focused on raising money to cover all costs.
So that campaign ended early May, correct?
It ended.
Of 2020?
The date that my campaign ended was the 28th.
So it's been a long time ago since then. Your
Correct.
filing was due on June 5th. Between early May and June 5th, what did you do to try to figure this out so you would file a complete and accurate campaign finance report?
We were attempting to get with JPL to get a final bill that we could use on in the report. Additionally, as it would turn out, my treasurer challenged a bill that came in, which is certainly within the campaign's right to do so. She challenged that bill. I've already testified that if I'd seen that bill, I would have recommended challenging the bill as well because it was inaccurate. And that is certainly something we're committed to do as we try to figure out what the bill, what our reporting is supposed to do. Again, I said this before, we have three options. Whenever a bill comes into a campaign, one is to pay it, which is reportable. The other one is to challenge it, which is not until you get the proper notification. And three is to negotiate it, which again is not reportable because you have to negotiate it. Those were the places that we were. The point is, we were in that process.
Your testimony is that Susan Jones disputed the bill.
Correct, she did.
She never presented to you or asked you any questions about the bill before she disputed it?
She did not.
Why not?
You'd have to ask her that.
So when she received bills on behalf of the campaign, what was her discretion to decide what to do with them without communicating with you?
I think you've seen exchanges in email where she did present bills to me and I approved the expenditure.
I didn't ask, what were any rules or guidelines you set up where she could dispute bills without ever even talking to you about them?
There were none.
Okay. Exhibit X from Mr. Bryce. Exhibits is the attachment. When you filed your filing to the Secretary of State on April 15th, or Susan Jones specifically testified she's the one who actually did the filing. When that happened, so this is much later than the April 30th of 2020, at which time you asked her to go get the bill, and your testimony is she never brought up that she had already received that one invoice. This is a year later, and you're filing something into the Secretary of State's office about a $290,000 invoice with other things. Did she not, at that time, notice that there was an attachment, or look at the attachment to the item that was being filed to the Secretary of State?
Objection to questions about what a third party looked at and noticed, unless he has personal knowledge of it. He's asked speculative.
Sustained.
Did Susan Jones bring to your attention that there was more detail than was being filed with the Secretary of State?
She did not.
Did you personally go and find this email in your email at that time?
I did not.
The items on this invoice, okay, what if any of them do you not dispute?
I have to dispute every one of them because I don't have the detail to give you an answer on how true they are. Without any detail, I just simply speculate.
Did you take any effort to investigate this when 3 weeks ago it came to your attention?
I opened it and looked at it and immediately saw errors.
Give me an example of an error.
Signs, 4x8s, they didn't do anything with regard to that. Yard signs, nothing to do with that. Stickers, nothing to do with that. And, my view is that this carries through for everything. If they're going to be wrong on the tiny things, how do I know they're going to be correct on the larger things?
How do you know the signs is wrong?
They were not purchased by Constant Content or JPL or anybody else.
Weren't there things that were purchased by Stephen Caraway that he billed the expenses for Constant Content on your behalf?
Not the 4x8s, that was payment through, we bought those through Patriot Signage in Cincinnati.
So were you aware, though, that Stephen Caraway was billing some expenses to Constant Content for your campaign?
During the campaign, I did not.
So the emails with that you weren't aware of, so you missed those emails also?
I was not involved in his billing.
How often did you meet with Stephen Caraway during the campaign?
Oh, we probably met, as he pointed out. We met probably once or so a week, maybe once or twice a week. Talked on the phone quite a bit more.
Who did you think was paying him?
I didn't know.
Did you ever seek information to declare him as an in-kind contribution?
I did not.
Why not?
because it would have been his responsibility and JPL's responsibility to provide that paperwork to me. And quite frankly, my treasurer.
I think that you've identified yourself as having a lot of political experience.
Yes.
I think there's a history where, for example, the HRCC provides invoices and documents to people for declaring in kinds. I've been involved in some local races, and are you aware of a legal
I would
basis?
object to the speech and
Are
ask
you
that
aware of a
that he
legal
gives the
basis?
Mr.
question.
Hicks, you need to ask the question instead of,
Right. Do you believe that in-kinds only need to be reported if somebody provides you paperwork on an in-kind?
I believe that's the way the law works. You can't report what, again, you can't report what you don't know.
So you've always provided paperwork for in-kind contributions to campaigns when you've held them?
It depends on what I've done. I mean, at the end of the day, if I'm going door to door, I don't think that's required to be an in-kind contribution. It's a volunteer activity.
Did you ask Stephen Caraway for a report of how much was being spent on him?
I did not,
Who did you think was paying Megan Fitzmartin?
JPL.
Did you ask Megan Fitzmartin for an in-kind or other report to declare her?
I did not, and that gets into the discussion that we had before. If I went around and knocked on every door and got every dollar amount, it wouldn't have been accurate because I wouldn't have picked up on how much, Caraway spent with my time versus Gene Schmidt's time versus somebody, he already testified that he was responsible for all candidates below I-70. So that would have been probably 8 or 9 different candidates. How would I know what percentage was dedicated to me and how much the percentage was for Gene Schmidt or anybody else? So again, it wouldn't have been relevant data for me to actually be able to sort through.
Did you ask any other people?
I did not ask any of the people.
On Mr. Bry's Exhibit X, that you provided the media things on here, one of the things that's, I think, here and is in the strategy and media invoices was the cost for producing the ads. Did you ever ask somebody for an invoice for the cost of producing the ads that you personally participated in creating?
I did not.
Why not?
And once again, it was during the campaign, and it was something I just didn't think to do.
So after the campaign, between the time the campaign ended and the June 5th filing, you didn't feel the need to do that either at that point?
I think I've explained that 3 or 4 different ways. If I had gone around and done the legwork, it wouldn't have mattered. And I'm sorry, Phil, to put you on the spot, but we did have an opinion from Phil Richter, as reported by my attorney, wait for a bill to come in. And that's what we would do. It became readily apparent later on that we weren't sure that a bill was ever going to come. So we needed to deal with how do you report it moving forward so that it was okay with the Secretary of State's office. It was important to me and important to others that we make sure that we report things properly, close up the books, and get moved on.
Can you look at Exhibit 15 in the stack that I gave you? In mine, Exhibit 15. So this is Scott Schweitzer's affidavit about constant content paying bills. I think if you get to the top of the page to, second page of the actual affidavit, S&P invoice constant content paid as invoices for work done in connection with Alan Freeman. So this was from June, not that long ago, really, it seemed like June 18th, 2021. Did you provide this to the Secretary of State's office?
His affidavit? No.
Yeah, so you provided something on April 15th about not knowing who paid the invoices. So I'm just asking, when you became aware of who paid the invoices in this affidavit of your friend Scott Schweitzer, did you feel any need to get that to the Secretary of State's office?
No, we just needed to make sure that the dollar amount was included so that they would be able to put the information in. Secretary of State's office was satisfied with the letter and felt that was adequate to the task.
So this April 15th filing, I received it because of an anonymous tip from the Secretary of State's office, not because of anything in these proceedings. Why was this not provided to me and to the commission in these proceedings when you made this filing?
Well, we were working with the Secretary of State's office, perhaps an oversight, maybe we should have mailed it to everybody. I did not know that I needed to provide that to you for approval.
Even though there was an active election commission case going on?
Again, I was focused on trying to get everything wrapped up so that we could move on from this campaign.
Okay.
And once again, I did not realize that I needed to clear it by you.
I didn't ask you to clear it, I just asked you to disclose it.
It was disclosed because it became a public document. When the Secretary of State's office accepted it, it became a public document. It was there for anybody to see.
So in your view, are there any other things that you filed that I would have theoretically received by doing public records requests to agencies where you filed them?
I'm not aware of any, but I'm sure that you could search that out.
So I'd what, make a public records request to every agency in the state of Ohio to see if Alan Freeman filed anything?
I think it would be very similar to me going to every television station trying to find out how many bills are out there that I would be required to pay.
So look back at my original affidavits,
Okay?
which is Exhibit 2. You keep saying, you know, go to every TV station.
That's what you did. That's what you did.
No, I went to the FCC database
Okay.
and downloaded the invoices. So I don't think, I just want to get your characterization. You guys think that maybe you should go to the stations on your specific invoices, not every station for anything, but just on your specific invoices to ask them, did this happen?
No, I did not.
So I think there were 6 invoices in here. It wasn't go to every station on everything. So you never felt, did you ask Susan Jones or anybody since these were produced in my affidavit to go research them?
I did not.
All right, hold on. We're gonna take a quick 5-minute break.
I'm almost done, I think.
We still need.
Okay,
Still
okay.
doesn't matter.
It's a desperate situation. All right, thank you. No problem.
Got everybody back?
You should have seen.
Mr.
what that
Freeman, are
place
you
looked
ready?
like.
Yeah.
I've heard you describe it.
I think I'll have one more question.
And it's actually pretty decent shape, almost.
Not this one.
Just teasing.
But unfortunately, my answer is going to be a 17-point.
Yeah, that's right. Thank you.
Let's
keep it going.
Nothing less.
Okay. After your, are we ready?
We are, we're all in.
Okay. After your June 5th filing, did you file any more campaign finance reports?
I don't believe so. I don't think we were required to.
If I told you that you filed, which is up on my screen, a January 28, 2021 annual report, would you deny that?
No, it's probably accurate.
Okay.
There was nothing to report.
There was nothing to report.
Yeah, no incoming revenue and no outgoing expenditures.
Did you ever, though, when filing that report, have any discussions with any of the people, this is long after the campaign's over, about do we need to do anything to show properly incomings or anything else that should show up on a report that is not?
Once again, I was reaching out to Megan and with Anna Lippincott. We were hoping, because we were following the advice of Mr. Richter, I had heard a rumor that bills were starting to come out from JPL sometime in October, and that didn't end up being the truth. So there was no, I mean, at that point, that was what we were attempting to do.
And the bill that you had received from Jeff Longstreth was constant content, not JPL.
Correct. Well, actually, what my treasurer had received, what I received in 2021 was from Constant Contact. I just want to make sure that was very clear.
But to be clear, the from email was jefflongstreth@gmail.com, correct?
I don't think so.
Okay.
I haven't looked at it.
I want to confirm it, I could be wrong.
It's fine.
And I apologize for this, I didn't mean to make that
I was just thinking that.
I criticize, but I do the same thing all the time.
I guess it's Exhibit W.
We all do.
I'm looking at my stack of stuff, and it's Exhibit W in your own exhibits. And I think correctly, the actual document is from QuickBooks notification, but down in the body of it, do you have an Exhibit W? It's from his book, so it's from Don Barnes' book. Or he has the book. He has it right in front of him right now.
No, I have mine, I don't have witnesses, I think it's on that.
I think that's mine,
Yeah.
that you gave to me.
But he just.
Right in front of the box on the floor.
He's got
On the,
it,
you can't see it, Don, and so, yeah.
Okay.
Oh, got it.
he's got it in his.
So W.
Thank you.
Right.
Okay.
In the body of the document, what's the reply email?
Body of the document,
At the bottom.
Jeff Longstreth.
Okay. Do you know what the JPL and JPL stands for?
Oh, Jeff Longstreth.
All right, so,
But can I also point out, I did not see this until 2021,
okay, so,
which was past the annual filing report.
have you had any discussions since then on filing a revised report? Or you can do that anytime?
That's what we were discussing with the Secretary of State's office, and that's the impetus of the letter that you brought forward
Okay,
through secret means.
and the hearing, the preliminary hearing was December 17th, 2020. You filed a financial report on January 28th, 2021. Did you make any steps before filing that report to investigate the invoices that were presented here in my affidavits?
And I don't believe I had them at the time, but no,
You would have had the invoices presented in my affidavits at the time,
the answer's still no.
okay? Did you ever consult with anybody about showing these amounts as an in-kind?
Other than counsel.
Is that what your question is?
Yeah.
No.
You never asked Stephen Caraway about in-kind?
Caraway wouldn't have had that information based on what Caraway told me. Anna Lippincott handled the finances. And that's why in May, he was pointing me back toward Anna Lippincott, because she had that information, not Isabel Ray.
But she never responded to you?
Correct.
Okay. I think that's all I did. I guess we're, but you want to sit real close?
It wouldn't bother me.
I don't think I have anything further.
Did you say you don't have any further?
For this witness.
I know that it's a shocking moment. Let's have a moment and take this in.
Does anybody in the commission have questions for this witness?
Are you in the comedy business?
Fortunately, no.
What business are you in?
I'm a consultant.
I do have one question.
Hold on.
Which way do you want me to say it?
The witness.
Catherine, why don't you go
Sorry,
first?
Chris.
Please do go for it.
Sorry, Chris. Chris is apparently not a close topic.
I also have documents that are mine, so.
My only question is, you said you reached out to Anna Lippincott, you left a voicemail. Was that one time?
Actually, I believe I did it more than once, but I just remembered a specific time that I did it. And that's why we put that specifically in the affidavit.
Okay, and do you recall following up after that?
Well, I continue to try to follow up with anybody on the campaign that I can find that would return my calls,
Okay.
in hopes that that would spur that conversation.
Thank you.
Mr. Bronner, I think you said you had some questions?
Yeah, I think you testified about Exhibit W. And you said, I believe, that you had not seen that exhibit until April of 2021.
Yes.
And I'm looking at the heading of that, and it says to Alan Freeman at zoomtown.com. Was that your email address?
It is.
So you're saying you never saw it,
I did not.
and it was sent to you, you would acknowledge it.
Apparently, according to the header, it was sent to me. I can't explain why it didn't arrive. We did have a situation in this particular case where a similar circumstance occurred, where my attorney attempted to send a motion for dismissal, and Chris did not receive it. So it's not uncommon that with modern technology, things don't get where they belong.
But apparently Ms. Jones received it,
Yes.
and you did not. Okay. The other question I have is, in your affidavit, you indicated that your campaign contracted with JPL Associates, correct?
Correct.
How did you agree to get them to provide services for you?
They were actually part and parcel to the endorsement of the speaker. So that was part of, you know, when you received the endorsement, this came along with it.
Okay, so specific to your campaign though, are you saying that, because I looked them up online and they're touted as being the biggest campaign provider in the, or assistance in all areas, media specifically in Ohio. And you said, I believe your testimony was, you never signed a contract with them?
No, because they're a part of my son. The way it operates in other spheres is that once you're endorsed by the Speaker's office, you're endorsed by the Ohio, in those days, the Ohio, it was the Republican Campaign Committee. So therefore, you'd be married up, and they would be your team moving forward.
But how did you know, I'm trying to get my head around this, it's your campaign with your name on it.
Mhm.
You contracted with JPL to provide media services for you.
Mhm.
How did you know what those services were going to be if you had no contract spelling it out?
Well, I mean, at a certain point, we started to discuss moving into television, whether or not we were going to do television commercials. And so that was the next step of the campaign. So we were operating off of essentially our campaign plan. And so those were the pieces to, you know, a larger campaign plan.
Okay, that's all I know.
Go ahead, Charlotte.
Yes, I've got a couple of questions. The first one, did you authorize all expenditures for your campaign?
The ones that I received, yes.
So you would have authorized any expenditure, any commercials, correct?
I should have.
Did you ever authorize any campaign commercials, any commercials, both video and audio?
I just want to make sure that I'm clear on the answer. I did authorize the artistic part, so the look, the feel, all those things. I did not authorize the expenditure to put them up on television or otherwise.
You just talked about the campaign plan. There was a plan to do commercials, correct?
Mhm.
You produced commercials, you participated in the production. You then saw commercials at some point in time, correct?
Mhm.
So who did you think was paying for the commercials?
Well, again, it is not uncommon for the ORCC to pay for those commercials and then seek reimbursement or to use those as campaign contributions at a time. What was testified to by one of the candidates is that ORCC has an unlimited amount they can donate to a campaign. So it is not unreasonable to believe that that's where the funding had come from to actually cover the cost of those commercials. In many campaigns that I've been part of, if you have a TV commercial, you only have X amount of money to spend it on, you put it into, you know, some sort of a smaller buy, and so that's how you operate, so you stay within your budget. So I did not authorize anyone out there to go beyond that budget.
So with that said, having seen the commercials, your assumption was the ORCC produced or paid for those commercials?
At that point,
Somebody did, right?
At that point, somebody did, I did not know who. And I still, to this point, do not know who.
But as a candidate, you don't believe it's your job to find out who paid for commercials that you produced, that you paid for the production, correct? that somebody authorized them, that you would either have an invoice coming into you, or you would have an in-kind contribution coming into the campaign, correct?
There's, at a certain point in the campaign, you're moving quickly, and a lot of things happen at the same time, and so sometimes details get overlooked.
It's a state rep race. It's not a congressional race, it's not a statewide race. It's not a huge campaign. I mean, even though you have 96,000 plus left, it's not moving that quickly. But you wouldn't know where the commercials were being paid, who was paying for them, with your picture in them, something your campaign produced.
As you're moving through the campaign, I got into the race on November the 25th. The actual primary date was early March, so we had a very compressed time frame. So we were trying to do a lot of things very quickly. And so when you're trying to move that fast with a lot of those details, there are a lot of things that happen at the same time.
But after the campaign, you have plenty of time to gather the information about who paid for those campaign commercials.
I had the ability I had a lot of time to do that, but how would I have found that out but for making that connection to Anna Lippincott or somebody else that's inside JPL? I did not have access to those folks that could answer that question. So I don't know, when we saw the invoice from Scott Schweitzer, it said paid by Constant Content, an organization I had no idea who they were until this began. I had no contract with, so I had no relationship with, and quite frankly, they no longer exist.
That's all I have. That's all I have.
You got something? Go ahead.
So, in Mr. McBride's, or not McBride, Mr. Bryce, McTide and Bryan now.
I've been called worse.
Yeah. So in Exhibit I, there are, I think, 6 or 7 invoices. Some are paid, and then the others are not, and that's what the invoices from Constant Contact. How do they determine which ones to pay? Who told them to pay which invoice?
As far as, if I didn't authorize it, I can't tell you who did and what their criteria was.
Because it seems like the ones that were pretty pricey were the ones that were not paid,
Yes.
and some that were a little, a little less significant were the ones that were. So I'm just trying to figure out who would have authorized those to be paid.
Again, I don't have the information to answer that question.
So who would have been overseeing this? Would it have been someone from your campaign, or would it have been someone different, or do you?
Well, in theory, they should have presented the bills to my treasurer, and then that would have come to me. It did not happen.
Okay. Thank you.
Any further questions for this witness from anybody on the commission? Your time has sailed, Mr. Hicks.
Before I could ask questions specific to things the commissioners asked about, when we've had other witnesses.
Anybody on the commission have any more questions? Mr. Brock?
I just have one. A couple
Oh, wait,
times.
hold on. You're going to have a question, Mr. Hicks is going to get a question.
Well, the one question I had, you referred a couple times to ORCC, Ohio Republican Campaign Committee. Did you in fact mean to refer to the House Republican Campaign Committee?
Yes.
That's it.
As I said at some point during my testimony, I did point out they've gone by many different names, so I apologize if I get it wrong.
Mr. Hicks, what's your question?
Okay, I clicked exhibit 18 here, which is your expense reports. My exhibit 18, it was also, I think, in Mr. Bryce's exhibits. I might have been these now, I remember looking at. So how much money did you authorize for the production of your media spots?
I would object. I think this goes beyond the scope of any of the questions that were asked.
Overruled. Go ahead.
Who would have paid for the?
No, how much did you authorize for the production of your media spots?
I don't believe it's in there.
I'm not asking you. I'm asking a question. You said you authorized expenses. How much money, ballpark, did you authorize for the production of your TV commercials and radio ads?
None.
So who do you think was paying for them then?
Red. I didn't know. My assumption was my campaign would be paying for them. It was either going to come through the House Republican caucus, or it was going to be, we were going to get the bill later.
But your testimony is that you said previously you approved all expenses. Then you just said you filmed commercials without having pre-approved the expense, but expected to be billed for them. Is that a correct representation?
Which if that bill had arrived, it would have gone to my treasurer, I would have approved it, and it would have been paid.
I feel like this has been asked and answered.
Many down on the
This is the fifth time we're.
So I'm going to have one other question.
Any further questions from anybody in commission? Thank you.
I have a question about the ORP
No.
endorsement.
No,
I'm going to ask it anyway.
I didn't get
Were
it.
you endorsed by the ORP?
I did
Move
not
to
get
strike
it.
Mr. Freeman, don't answer the question. Mr. Bride, do you have any further witnesses?
I don't think so, but you don't need to leave. Subject to my proffer, which I'll do in writing, of what I would have testified if had allowed to, I think they're right. Well, and also subject to admission of our exhibits.
Mr. Hicks, do you have any objection to any of his exhibits?
No.
Okay. They will be deemed admitted. Commission members, we're going to go to the closing. How long do you think we should give each side? 15 minutes?
Well,
Did you say 5?
Yeah.
I think 10 minutes is
10 minutes, I
reasonable.
think would be good, yeah. As much as as much concluding arguments as we've heard during the presentation.
Yes.
Yes.
Without the question.
Right.
And, yeah.
10 is fine with me, to the extent that it was fine with me minutes.
Let's do it at 10 minutes.
Great.
Mr. Hicks, I don't care if you do it from your table there. If you want to do it from the podium, you let
Well,
us
no.
know.
Okay, I'll do it from here if I can. It's okay, because
How's
I
that
actually
fit?
have more material, as you might expect, than 10 minutes or 15 minutes. I'll try to accommodate as best I can. But I think this is an important case, and I don't want to be, we were constrained to 5 minutes in the openings, right? And I just want to, what I'll do is I'll go through these and flip past a lot of pages. And there's some of them that have videos and so forth on them, but I'll try to flip past them to avoid.
With the permission of the commission, I wanted just to hand my proffer to the court, of course.
That's fine.
Before you start, I was just gonna say, I'll indicate when you've gone through 5 minutes, and I'll probably indicate when you've gone through like 8. And then, your time will be up, okay? Just to give you a heads up on that. I don't wanna just kind of interrupt what you're doing.
Can I, procedural question, do I get a copy of the proffer that you just handed in?
You should.
I think you should.
Yeah.
It's going to be it's a matter of the record.
It is by the record, if I don't give it to you, give it to me.
Okay. Yeah,
I
I'm
wanted to
gonna try.
pass it out to everybody, I suspect.
Good try.
We've killed enough trees, thank you.
Yeah.
I'm gonna try to do something that you've never heard Chris Hicks do, be succinct and fast going through these.
What?
Mr. Director, you tell me when you're starting your clock.
Anytime you're ready.
Let's
I
go.
will mark, get set, go. So I just want to say that I'm skip past it. I gave statements at the beginning of the things that I was going to approve. And I laid them out. I actually had a little clip of the video of the things that I said I was going to approve. You know, and I don't even think I need to go into it. I think if anything, I've redundantly proven again and again these things. And so I'm just going to keep going. In my materials, there is I put this slide because it relates to a couple of the code sections knowingly. Now, I don't think this is even, I just want to make it because it relates to a couple of the code sections. And one of the things I think that's ORC 290122, it's not something under your purview, but it's the word knowingly is in some of the statutes that are under your purview. And knowingly, one of the points I liked in this is, well, I think it goes way beyond this, acts with conscious purpose to avoid learning a fact. Acts with conscious purpose to avoid learning a fact. So I'm going to keep running here. So what I did is I had a clip from
He didn't just sit.
I'm going to play just a few seconds of it. I had a clip from the December 2020 hearing.
He didn't just sit on his hands saying, gee, they've never presented it one, so I
And I
don't
could listen
need
to
to worry
more of
about
that, but I
it.
just wanted to
He had
recollect
his treasure
your
of content,
memories a little bit.
try to get in.
Of what were the representations made at the preliminary hearing. And a lot of those representations are, we didn't do anything, we didn't know about anything, we didn't. So, so I think part of this is, to me, not only have I proven this, but I've also shown that there's been a consistent pattern to evade accurate, complete campaign finance reporting, which I think is a disgrace. So we know that on April 1, 2020, they got this invoice. The invoice was 4 months before any indictment, so this whole conflating of the indictments is a non-starter. That was not the issue in April 1 of 2020. The campaign was still going on. The campaign was going on for almost a full month. April, in his affidavit, he talks about, Mr. Freeman talked about having Susan Jones go do stuff where she had a different story. And I just want to point out at some points here, the phone numbers for JPL and Constant Content people were the exact same. Their address was the exact same. They were the exact same people. Other candidates got their invoices from Constant Content, like Gene Schmidt, and paid their invoices. So we have a unique situation here, and the primary ended on April 28th. So we know in spades, Mr. Freeman participated in all of the stuff, and there was never anything. There wasn't production cost, any cost recorded whatsoever, and there was just a plethora of testimony of Scott Schweitzer, Stephen Caraway. I don't think any of these people were hard to get to. None of them testified that they were so busy and out of control they couldn't take a phone call. Okay, they were at a different pace apparently. I provided a bunch of invoices. I want to note that the invoices that were in the affidavit were 5 months before there were any indictments. Invoices of Constant Content, Freeman giving approvals in spades to these things, but apparently his testimony, I was only improving creative. I didn't think anything would ever be done with it, which makes no sense if you're so busy on a campaign that you don't have time for anything superfluous, but you're making commercials you intend to never approve.
So we had.
I put a series of clips of people, one after the other. Stephen Caraway talking about the size and scope, the conversations about needing to pay off the debt, which also makes no sense if you only spent $14,000 and have $96,000 in the bank. It all makes no sense. I don't know how you could have a more extreme example of flaunting any concept of filing a complete and accurate finance report than we have before us here. The post-primary was filed on June 5th. That's almost 2 months before any indictments. And over 2 months after they had the April 1st invoice from Constant Content. The affidavit, beat that to death. This filing, the notion, I mean, even here, that theoretically I would have figured this out because I would just be doing public records requests when there's an active case going on. I am not a lawyer. I've not been in court because I was in trouble or anything, but I've watched judges. I can't imagine how, in even my county, a judge would react to this kind of stuff happening before him if this was an actual judicial proceeding and some of these representations were being made. So I'd like to point out they never looked at the detail on April 1 when they received the bill. December 11th when Freeman signs an affidavit. April 15th when they send a statement into the Secretary of State. June 18th when Schweitzer files an affidavit saying Constant Content had covered the invoices for your campaign. And October 7th before the full hearing. Before we started the full hearing. There were tons and real people got hurt. Nick Owens got hurt. This was a 300-something vote difference in an election where you have large amounts of time left. So the big thing that Don Bry likes to bring up is when did they know? I'll skip past some of these. Well, okay, let's ask the no question. So they knew the FCC database had the invoices on dated 20 of March. That's 608 days ago. I'm going to go down this list and call out the big ones. The Constant Content invoice was April 1, 2020. That was 596 days ago. The primary voted ended 569 days ago. The post-primary report was due 531 days ago. The indictments happened a couple months after the post-primary report. So that was 476 days ago. And I'm going to go back down here. 294 days ago, they filed another report, another campaign finance report. So this knowingly argument, I find almost, you can't report what you don't know is almost comical. Because you knew. And you had every basis to know. You had every reason to find out, every basis. And I just can't imagine, I think about the motion to dismiss, the notion that these kind of arguments people would even bring before this commission. It's a complete absurdity that people would think they could pull off these kind of arguments relating to a campaign. So we think we heard throughout, Fitzmartin, Schweitzer, Jones, what this means here is, did they distinguish between JPL and constant content? And pretty much everybody who testified, it was one and the same to me, I didn't know the difference. I didn't have any confusion between Anna and Megan throughout this thing. And Caraway, he bills his expenses to constant content, his payroll to JPL, which by the way, never shows up on a finance report anywhere. Never shows up on a finance report anywhere as an expense or an in-kind. So, he has a lot of political experience. Freeman has tons of political experience. And I think, I put this here, this has all been intended to wear everybody down, including me. But I don't wear down easy, and I apologize for all the offense I've caused to all of you through time, but I don't wear down easy. This is right and wrong. This is fundamental right and wrong. And really, separate whatever happens in a future term, it shouldn't be this hard. This is such a ridiculous example of somebody trying to run away from accurate and complete campaign finance reporting. So here's the code sections that I cited. How many minutes do I have left?
2.5.
2.5.
Yeah, 2.5.
So I cited failure, I'm not going to keep saying the code sections because it will take too much time. Failure to keep a complete and accurate statement, fail to strict account, acceptance of direct corporate contributions. Those were the three things that were in my three affidavits, okay, to be true to that was exactly what was in there. I point out that there's potentially another thing that's not in the affidavit about contributions above the limit, and I think there's referable things all over the place here on election falsification and pattern of corrupt activity. So complete and accurate statement, full, true, complete, under penalty of election falsification, which is one of the knowingly things in the statutes, election falsification, I probably have it in here, is if you knowingly do this, so complete and accurate finance statement. The fine for that is a shall be fined $100 per day for each violation. Okay, so I say I don't know how this isn't the most ridiculous example of a case. It's been 531 days since the June 5th finance report was done. That's $53,100. At some point there has to be a statement in Ohio that this is not going to fly. We are not going to let just ridiculous things fly in terms of our campaign finance, especially given some of the issues we've had. The strict accounting one, I can't actually find what's the violation for strict accounting? I looked as best I could. Corporate contributions. So if Constant Content paid this stuff, one of the issues he has, if he puts it down as an in-kind from Constant Content, it violates other laws. Because it would be a corporate contribution. Constant Content is a corporation. If you go with what he said, JPL is an LLC, and that's a different law in terms of what the offense is. Acceptance of direct corporate contributions is both the company's responsible, and Section B1 of that statute makes the candidate responsible for receiving those corporate contributions. And by the way, contributions not distinguish cash or in-kind. You can't say because it was an in-kind, it was okay for a corporation to do something. And then claim 3, the violation for this code section of a corporate contribution is a $1,000 fine and up to a year in prison, which I know you don't do the prison part of that, okay? And I want to just hit real quick here that this is an important point to remember too. He still owes the money. So when these kind of things happen, what happens is that money is due to the state. That money is due to the government at that point in time. It doesn't just go away. It doesn't just disappear into the ether. Because when criminal activity is involved, it doesn't.
That's 10 minutes.
Okay. So, last thing I'll say to conclude here is, I put in here that I think this should be referred on a pattern of corrupt activities. I put the code sections back here that actually refer to the federal statutes. And if you want to get a good idea of what those things are that could be cited, just go look at the Larry Householder indictment, of which Jeff Longsworth has already pled guilty. The same things were happening on the campaign side as were happening on the dark money side. The same things were happening.
Thank you,
The
Mr.
same
Hicks.
racketeering.
Crawford. Yeah, you can get it, it's a matter of public record.
May I move the podium?
Certainly.
Does it count first time?
No, I haven't started yet, just like I didn't start until I said go
I was
ahead,
trying
I'm
to
doing the
get-
same thing here.
I don't know that I object to this, but I think that these things are, in many cases, out of context, and he should have cross-examined me on this document. He's taken things out of my overall
His 10 minutes are
deposition.
exhausted. I do not object to what you put on the screen. This is the same thing as sort of highlighting my view of the evidence. He's already highlighted this with the 10 minutes that is exhausted.
Great, you ready to start, Mr. Bragg?
I am, thank you. Mr. Hicks says this case is about right or wrong, and I'm inclined to agree with him. It seems to me that somebody broke the law, and that somebody were the folks who have been indicted. Some or all of it, who knows? I mean, they'll sort out the criminal case. But it is clear from, as he pointed out, there's been at least a guilty plea by one of those individuals, that they were using money and not properly reported it to whoever they needed to report it. And that includes my clients, that they did not properly report what was being spent, who was spending it, and what was a debt and what wasn't. They figured as long as the money keeps rolling in, who cares where it comes from, as we remember from the view. Well, they do care who it comes from. We cared who it came from. He says, well, Commissioner Tavares says, well, it's just a House rep race. It should have been just a House rep race. It was actually run like it was a congressional race. In terms of the amount of money, at least I've seen thrown around in the numbers. We don't know if those numbers are real or not, but we have seen them thrown around. And to say that something was done wrong and somebody should have done something is different than saying, Mr. Freeman and his campaign committee did this thing wrong, and they should be punished for doing it. Those are different things. I understand that there's probably some activity that was unlawful. I believe there was, but we didn't do it. Now, is there any evidence that we knew? He said, well, you could have found out. Commissioner Tavares says, well, couldn't you have just figured it out? How do you get somebody to call you back if they won't talk to you? During the campaign, it was actually run more like a congressional race, and he was running raid. Other people were doing the media. He figured, okay, you're going to get it paid through HRCC, you can do unlimited amounts. And by the way, HRCC or ORP, the Ohio Republican Party, can also pay for folks that do field work without even reporting that as an income. We've heard testimony about that. So that kind of, his knowledge or lack thereof on that sort of goes away in a household thing. In terms of the other, he didn't approve it, but he did notice then how much money is in his campaign committee on a real-time basis. And why is that important? Wherever it's coming from, you can't get blood from a turnip. And he never authorized anybody to spend more money than his campaign committee could reasonably pay if they were actually going to have his campaign committee pay for it. If somebody else says, I'm authorizing this, and I'm going to be responsible for it, well, that's fine, but you still need to know, and they need to tell you who's paying for that and how much is being paid. And they cannot lawfully have a corporation do that. But the prohibition, as he said, is accepting a corporate contribution. Accepting means you know that it happened and you were okay with it. Accepting does not mean some corporation, hypothetically, we don't even know if this happened. Hypothetically, he's saying maybe it was an LLP, maybe it was a corporation, maybe it was this, maybe it was that. You can't report maybes under a penalty of election fraud. You report what you know, and you cannot report what you don't know. Well, did he take reasonable efforts to find out? What did he do? After the election, first thing he did is he calls up his treasurer, says, I need a final bill. I'm pretty sure I owe something. And he talks to Steve Carrollwood, he talks to Megan Fitzmartin, and they say, talk to Ann Lippincott. She's the numbers guy. Talk to her and she'll tell you what the deal is. And he calls her up. He leaves a phone message. He tries contacting her another time and follows up, at least another time. And, nothing happens. It's crickets. And after the July 22, 2020 indictments that we all read about. Well, we're not really expecting a lot of further information about that, which is why a week later, you know, he learned through Phil Rickard that whether Phil says it or not, it's the law. You can't report what you don't know. And I know, Commissioner, well, it does not mean you can just blindfold yourself. No, it doesn't. But I would respectfully suggest that we didn't just blindfold ourselves, that we followed up as best we could. We followed up and we knew that somebody has to pay for this. We knew that there are ways it could be legally done. We were told it could be legally done. And we followed up with the people that we had contacts with and, you know, knocked on their doors, and they didn't open the doors. They didn't say, this is how it's being handled, and this is what you report. We don't know the numbers. We don't know whether it was an in-kind or whether part or all of it was going to be a debt. We don't know what radio stations it played on. Yes, they've got the attachment to the complaint, but we don't even know if all those actually ran. And we don't know the dates that the expenditures allegedly took place. You know, and yes, he talks about Exhibit W. We've dealt with that. I mean, come on. Exhibit W should never have been sent. Mr. Freeman's testified that the attachment, which he hadn't seen until a couple days ago, clearly has things that they never did for him. Maybe they did it for somebody else. Maybe it's somebody else's bill that they got sent to. But they did not do it for him, and he knows to a certainty, stated on oath, that what they have invoiced to him, at least in small matters, is wrong, and in large matters, he can't confirm it. You know, that's a good reason to think that their statement, we shouldn't have sent this to you, it was a mistake, ignore the bill, meant that they shouldn't have sent it to him, it was a mistake, and that it was proper for them to ignore the email bill. You know, maybe if the email went through, he could have had it earlier, he didn't. That's just life in a big city. In terms of the $138,000, which is slightly under that, of the invoice that was sent, not to Mr. Freeman, not to Mr. Freeman's campaign, not to Susan Jones, but from Strategy Group to Constant Contact. Now he says everybody knew who Constant Contact was. Well, a lot of people did. He didn't. He had no idea who Constant Contact was. He had no contract with Constant Contact. The card he got was with JPL. And yes, it wasn't a written contract. He certainly understood that ads were going to run, were running. He reasonably, I would suggest, assumed that if I'm not approving the amount of these ads, somebody else is, who's either going to be responsible for paying for them or responsible for paying for them over and above the amount that I have in my campaign account that they already know about. That's not an unreasonable assumption. And you follow up when you can, and in his case it was a couple of days after the election, and knock on the door and ask for that information, and you don't get it. What are you supposed to do? Mr. Hicks has run around all over the state and gotten documents and talked with witnesses and presented a couple days of testimony here, and we still don't know what they were. In-kind, unapproved, debt. We still don't know the exact amount. We still don't know the exact dates. We still don't know, and Exhibit Y doesn't tell us because that's inaccurate, what they were for, even in terms of category. You know, this is not the case of someone who is willfully ignorant. This is the case of someone who is trying to find out and wanted to report things and be done with it. You know, he was a walking dead man as he put it, and he was politically. And nobody was answering his calls, and they were paying attention to him because they had hot live wires. You know, they had hot irons in the fire of people who were worried about November, and they were ignoring him. It's not his fault that they were ignoring him and not answering his calls. And so he did the best he could to try to find out that information, and he couldn't get it. And after July 22, 2020, nobody's been able to get it, including Mr. Hicks. Speculation does not satisfy the burden of proof. I understand, and unfortunately, Mr. Berman was correct. The standard in motion to dismiss is different than the standard now. But now the standard is he has to prove his case. And he has the burden of proof. And speculation and conjecture is not enough, and you don't have the right to ignore all the evidence we present that pretend that it didn't happen. I would respectfully suggest that this case is a dead man walking and should be treated that way, and the commission should dismiss all charges against my clients, Mr. Freeman, and the Freeman campaign.
Thank you. Now you're in charge, Otto.
I don't make recommendations on hearings, because that's what the evidence is intended to provide to everyone.
Procedurally is the next thing.
Procedurally, but certainly we can have a conversation, excuse me, here amongst members as to any particular perceptions, et cetera. As I tell anybody almost any time, generally speaking, the commission will make determinations at the conclusion of the presentation of evidence in any matter before us, make a decision at that point. However, by statute, the commission does have a 30-day period in which it can take a matter under advisement and then subsequently issue a decision. We obviously did that in the Travis Elkins case, that the commission took into consideration in March, I think it was. And actually, we also did it in the Doralia versus John Parks case. So it is something the commission has done recently. It is not something the commission has regularly done, but it certainly does have the ability to do so. And so, if that's what the commission decides it wants to do, based on general conversation, I can certainly begin to prepare something for the commission members if that's what they would prefer me to do, as we discuss how to proceed from here.
Okay, all right. What is the pleasure of the commissioners?
It seems to me, because of the amount of evidence and information you got, we certainly should take it under advisement. I think it's probably noteworthy that this should be, I think, a written decision. Do we have the ability to go into executive, to discuss this, executive session?
As I don't know that I would say it's an executive session. I have been elucidated by primarily Ms. Cunningham that my long-standing interpretation of how the commission is obligated to proceed in terms of only conducting its deliberations here before everyone it has not been affirmed by the courts, let's put it that way, and that if the commission does decide it wants to go and deliberate on a matter, it has an ability to do so.
You also talked to
I talked to the Attorney General's office as well, yes, and they certainly gave me direction. There are a variety of cases that were provided to me by the Attorney General's office. I guess that's the only one I really should refer to at this point. And so if the commission would like to go off on its own and have those kind of conversations, it is not something, it is out of the ordinary for the commission, but it is not something that is improper under the law.
Any comments, thoughts?
Well, I think we should take the first issue first, and that is, do we want to take the 30 days that we have taken in previous cases? Then I guess the next question is, do we want to go into executive session at some point? As far as the 30 days, I think given the scope of this case, it makes sense to me, and I note we do have a hearing coming up on December the 16th, which would be under that 30 days, but
Just for information, the 2nd and the 16th are both days
right.
that are available. Coming up in the rest of the year, they're available to the commission. Just as a point of order.
So I would move that we take the 30 days to deliberate this case.
I would second that.
Seeing that we had a motion and it's been seconded, we'll take a roll call.
That is more than fine. Ms. Cunningham,
Yes.
Ms. Kaufman,
Yes.
Ms. Tavares,
Yes.
Mr. Norman,
Yes.
Mr. Brommer.
Yes.
Hold on, I'm keeping up with my own handwriting here. Chair Beatty.
Yes.
That motion passes 6-0. So again, we have an ability, I don't think it would need to be necessarily going into executive session. I think we would just need to, we either need to go to a different room or ask everybody else to proceed out of here. And the commission has an ability to conduct its deliberations, not necessarily going into executive session. Just what the courts have essentially said is that an adjudicated body, like the commission, no different than a judge, has an ability to conduct its deliberations in a manner in which it believes appropriate. There are, I think I was provided with about 7 or 8 cases, which I don't have at my fingertips, but if you gentlemen would like to see them, I can certainly provide them to you, even later today potentially. But, you know, that is what I have been provided with and has been confirmed again by discussions with the Attorney General's office, so.
Yeah, I'd be interested in seeing the case, if you provide me Mr. Hicks's probably time for as well. That's contrary to my understanding, but my understanding is not always what the law says, so I'm going to be educated.
Well, again, it was something that I believe, based on my interpretation of the statutory provisions in the commission, but in further conversation, again, with Ms. Cunningham and with the Attorney General's office, they confirmed that the commission, as an adjudicatory body, when it is conducting its adjudicatory proceedings, not when it's conducting its administrative things. So like, just as an example, we approved minutes today. That's not adjudicatory. We have to do that at a public meeting, in a public session. They talked about conducting my review next, at the next meeting. That is an administrative and not adjudicatory. But as we go about deciding
That's an
any,
exception to the sunshine law.
Yeah.
well, but that's sunshine.
Yeah.
But that's,
Well, it's the same
it's
thing. It's
administrative.
the same thing, though. It's quasi, the theory is that the case law says that it's, when you're in a quasi judicial hearing, it is not a public meeting, technically. It's open to the public, but it is not a public meeting. So you don't need an exception to the sunshine rule because it's a quasi judicial proceeding, not a public meeting subject to sunshine rule limitations. So the theory goes along those lines, which is why Phil's talking about executive session. And certainly, if there is an objection to that, should the commission decide to do that, please make it.
Well, I'll make the objection, but only because I need to become wise before I continue the motion.
No, before we went through it today, I don't think so, before the commission. Executive session.
I would make no objection because I think your analysis is exactly right. The quasi-judicial body has to have the hearing in public, but can have the deliberation in private. I think that's actually in the statutes related to the start of the Ohio Administrative Code. But I totally agree, you can do your deliberations not in public.
Okay, do we need to have a motion on going into executive session?
On deliberations.
On deliberations.
Other public
Take us out of the room.
deliberations.
Right, it's not, again, it's not an executive session, it's just to go into the deliberation aspect of consideration of this matter.
And assuming if we do that, would we do it either on the 2nd or the 18th?
Or
Is that what?
both right now. Now.
Oh, we want
Right,
to
we
do
can do it right there,
right
We'll
now?
spend an hour now.
You can do it right now.
Or at least for now, you don't have to do it.
Right.
I personally, there's a lot of exhibits, I'm gonna want a little bit of time to take a look at them, I think. Beyond just, discussion, we get a lot to think about, and I think this case merits our attention,
Let
so.
me ask you this, if we as a commission are to deliberate, can we also do it on another day when we click on a Zoom link as well? With the
I would
six
say
of-
yes,
with the six
because
of us
we're not
present?
obligated, it's not a public meeting, and so therefore we're not obligated to conduct it in public. And so we could do a Microsoft Teams.
I think that would be recommended, only because it gives us a little time to digest everything we got. So I would we move into a private deliberation, and then we do it by way of Zoom Teams. Phil, will you participate in that?
Yes,
So you would be able to coordinate with all of us?
yes.
I would ask that the executive director, as part of my motion, to schedule that, and we do it that way.
And certainly, I agree, but I want to say that we need to do it so quickly that should Attorney Brian want to object, we want to make sure that we give him time that he can register an objection. I understand that complainant doesn't object, but.
Yeah, and I appreciate that. You're probably right, it's just,
Great.
I like to do belts and suspenders.
So I only say that to, and Thanksgiving's next week, so.
I
gotta
was
be-
thinking next Thursday
Yeah, it's Thursday.
was when we would do it.
Yeah. Well, everybody be home with turkey.
I'll be home,
Fat
I'll be
full.
home with 50 people in my
I'll
house.
be,
No, I'm available.
so, just,
So I made a motion.
Yes, it has not been seconded. The
Second.
motion. Okay, thank you. We now have a second. To go into private deliberations, do it by a Microsoft Teams meeting at a future date, to be
Right.
determined.
and I think, yes. At least how many days do you need to digest and
Just not even taking it. I mean, if he's
When I
got
get
the-
done here, I'll go, just for informational purposes, I got an email from Janine Hummer,
Okay.
who you all know, who said, hey, just to bring this to your attention, I then passed that along to EAG's office. This has been a few months ago, in terms of discussing the deliberations on the aspect. EAG's office got back to me, so I will forward that email to you that contains all the cases that were referenced there that talk about, you know, not obviously we did the same thing.
No, I don't think it's gonna take me but a couple of days to read, because he's already in the research, I'm not gonna have to do my own.
Right, so give them a week.
Mm-hmm.
I'm just saying, don't schedule us for until next week. Yeah, don't schedule us next week, it's a holiday.
And then the next week is our
The next week is
regular
the second
scheduled,
meeting, right?
scheduled meeting.
Yeah,
I'll reach out to everybody and we can.
we'll figure it out. We can do some there, here too. We're gonna be here anyway, we'll see.
Okay, roll call vote?
Start at 8 o'clock.
Well, that, no, you'd be okay.
7 o'clock.
We're doing it remotely. Roll call vote?
Sure.
Okay. Ms. Kaufman,
Yes.
Ms. Cunningham,
Yes.
Ms. Tavares,
Yes.
Mr. Palmer.
Yes.
Mr. Norman,
Yes.
Chair Beatty.
Yes.
That motion passes unanimously.
Move to adjourn.
Yes.
That's your seconds.
Second.
All in favor?
Aye.
Oh, we don't need a roll call for that?
No.
Just wondering.
You can just wander off, then we'll go.
So you can take over your binders with you?
Yeah.
Oh, you really?
Okay,
Good.
stuff and all.
Safe journey.
Don't forget